Hello, hello, hello. Good morning, everybody. Hold on a sec. It's all right. Good morning. It is May 28th, Wednesday. We are all primed and ready for our continuation of Crapature. Thank you, LexisNexis. Bob's in the shower. I just got out of the shower. Probably do a little trade-off when he gets out of the shower. But so I tried to catch up on some of yesterday, and you know, I just found the whole thing like stupefying. Like I still cannot get past the whole, Bob kept saying it, and I think you guys kept saying it in the chat, like he would have been run over in his little reconstruction at 2 miles an hour, like John O'Keefe would have been plowed down. But I was rewatching it, and he's like, the way he's standing, the way he turns is just insane. Like I couldn't figure out like why is he turning that way? When clearly if he's that far behind, like you guys all said, he would have been plowed the fuck down under the car. And I was thinking they're trying to say that the tail light broke from the glass, but he does his little reconstruction, and the tail light, the glass is way past the tail light. He's got his arm. He's standing really, like it makes whatever little scratch over, like way over towards the middle more, so that he can get this part of his arm directly on the unbroken tail light, which again, we still haven't get past. And he like threw himself on the car, like you just said here. Somebody just said it. Yeah, Holly. But then he like steps, turns. It's like, what in the fuck was I watching? How was that what was supposed to be happening? And then there's an objection like, did he just try to act like that was a recreation? And Brennan keeps asking the question like, well, when you were walking over to the passenger side, what were you doing? He's like, oh, I was just telling people what to do. And he was like, oh, that wasn't part of the reconstruction. No. What the fuck are you talking about? Literally, they were talking about when you did the whole stop and roll and walk away from the car in the actual not reenactment of how the paint got on your arm. And again, if the paint is on the arm, the glass is nowhere near the taillight, you're doing your little step and move, how in the fuck does your eye get scratched from the whatever that thing's called? The flappy dappy, the ski thing. What the hell was it called, for God's sakes? because doesn't he have to make all of the things be able to happen at one time? I mean, it's one thing to show it's a possibility because of the level of the tail light to the arm that something on a tail light could have made injuries to an arm. And it's possible because of the level of the bumper and the knee. Here's another thing. How in the fuck did they let him use his knee? Yeah, you're the same height, but we have no idea whose torso's longer, who's these, like, let alone because Bob's like, I was yelling this at Bob this morning. He's like, plus we don't know the position of John. Yeah. I mean, they made that abundantly clear. I mean, literally the first question on redirect, or I mean, I'm just talking shit right now. On cross doesn't really need to be the first question. I'll say it could be the only question. It really can't be the only question. I just like a flair for the dramatic sometime. But sir, after all of your testimony and everything you said, do I have this right? You could not construct the crime. Is that what you told the jury? You actually could not reconstruct the crime because that's what he said. He used the words, oh God, what did he say? Every which way, or it was like, I can't remember, but I kept repeating the words this morning to Bob. Like, he said there was just so many different ways it could have happened. Like, but there was something that he said. I don't get it. But going back to where I was, the knee, you have to show that the knee hitting a bumper and the arm in the exact location hitting the taillight and the hand. Okay, you got the hand and the taillight at the same time, that I get. The knee also has to get struck in the same thing, so you can't be turning already. But plus, your eye has to be this way. All of the things have to be able to happen at the exact moment. Could you recreate that, sir? Could you recreate a situation where every injury on the body you claim happened from the car happened with the same vehicular movement or vehicular/body movement? Because I can't imagine in a million years how all three, I'll call them three, even though they're four because of the hand, but he did that thing where it's like my hand is yellow and this is blue, whatever, that all those happened at the same time. But if you recall, he's got the hand super in front of him, and then he starts to walk immediately backwards and around. Oh, geez. It's like, it's like, what world am I in? And then Bob just keeps saying, I guess they decided they don't have to prove the taillight because what they think they proved, right? That the taillight didn't shatter in John O'Keefe's driveway. So they're not even going to touch the taillight. How the fuck does it shatter? Because again, I thought he was saying from the glass, that this is just what my mind was like, all right, well, then the only thing he can be saying is the glass shattered the taillight. When in the fuck does the tail light explode if the system does not even register a triggering event? Mickey says, good morning. Still saying with arm giving a push inward force to light. Light exploded outward into the yard versus dropped to the roadway. Ridiculous. Again, another insanity. Because that's what physics says. I mean, I'm not a physicist, I'm not a scientist, I'm not a reconstructionist, but I'm pretty fucking sure what goes up or what falls down to the ground. But that's gravity goes downward, not exploding outward into the yard. But even if there's some explanation for that, which there's not, right, Mickey? And I just like to add to Mickey's, and I think I did this yesterday with this very good point, is the glass. When did the glass break? Because how is the shards of glass up on the snow? How did it all get into the yard versus the roadway? How did it get in the yard versus the roadway? I mean, maybe he's really not going to come back to that today. maybe he's saving it for last. I mean, I don't know, but I'm dumbfounded. Giggle Glimmer, thank you. Good morning, fam. Who else has an I mean, how come he doesn't know how to say the right? Is he the only person that calls it the occipital instead of the whatever it's really called? I mean, I'm like, it's too early in the morning for me. I barely hopped out of the shower. But I don't know, people. Like, did anyone figure anything out overnight? Because all I got was just more confused and more irritated overnight. And this morning, because I tried to go back to some other stuff I missed this morning, and he said something. God, there's something he said this morning when I was like, oh, yeah, that it could have just gone so many different ways, and it could have been so many different things, and it could have been this, and it could have been that. I was like, so basically, you're saying you could not reconstruct the fucking crime. It's just, I mean, I almost wanted to reach out to Mel and like vent to her too, but I figure she does it all day. Do we really want to do it to each other after hours? I mean, I don't know. You know, it's like, and I got Bob, so I can vent to him all day. But I like, for the life of me, seriously, I just don't know how the judge allowed that fucking walk yourself into roll off, like you're doing your hand paint in school reenactment thing. I just don't understand it. I want to go back to it. That's what I want to do. I want to just watch it right now. Let's just see if I can find it real quick. Oh Lord. Let's see. And I don't know what I did. I somehow got logged out of YouTube on my computer as Bob, and now I'm getting commercials. So I still just never took the time to figure that out. I'm just gonna try. Go back to yesterday. Where is yesterday? All right, I need to go live stream. Okay. No. Okay. Let's see if we can find it. A fucking paint roll. I can't remember. Was it before? Was it after lunch? No, we're back in John's driveway. How do we get back in John's driveway? Oh, here we are. Oh boy. Okay, hold on.
All that information.
We're just gonna.
We know the tail light was broken.
That thing
we know
running
the glass
over there
was broken. We know you get on.
First was him rolling himself in. Get the
of the lacerations.
That was him rolling himself into it.
Miss.
All right.
So now I said, okay, that was me walking into the car.
Okay.
Let's have the car drive into me.
Let's have it.
I did this at very low speeds.
I can't zoom in on it.
And you'll see, and we'll throw this from two different angles.
All right, standing with the arm outstretched.
I'm doing test 2.
Wait, what? Wait, what?
I'm doing test 2.
Wait, he did kind of lean his face in. I can't make it go back. Well, so it's that thing. Is it this thing up here, you guys? Is this the thing? I know this is like a camera or something. I'm talking about the part that projects. Let me see if you guys can see what I'm doing over here when I do it. Can you see what I'm doing it? Because I can't watch both screens at the same time. But this little ledgy thing on the top of the car is what scratched John O'Keefe's eyelid. I'm coming back in here to chat to see what you guys are telling me here. Before I do that, I'll just stop right here and say, not that Mikey. Now that one's Mikey, right? My question is, how many times did he have to do that experiment so that he could get that silly paint on his arm they're leaving the jury to determine for themselves versus proving a case beyond a reasonable doubt. I mean, yeah, very good question. Very good questions. I'm coming back here to see if you guys tell me, is this, oh, they're coming into the courtroom. They're coming in the courtroom. All right, we'll revisit this. Let's see.
All right.
She looks
Good morning, everybody.
not happy-ish.
All right. So,
It's ruling
Dr.
time.
Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied.
Wow.
In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application.
I don't think so.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology.
Rewind. Sorry.
Ms. Reed's Lexus collided.
I'm sorry, because I was still thinking, my brain was still processing like the last thing she said. So deep breath, Here we go.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
I want them to say we did have an objection.
So the jurors are lining up.
Like
we should have them momentarily.
They did. No, put it on the record. Your Honor,
okay.
We did object to his methodology. Pre-trial. Wanting to voir dire him.
Is Dr. Welcher right around?
Wanting to voir dire him on his methodology.
Why don't we bring him in if he's here before the jurors?
And looking to exclude him based on lack of methodology isn't an objection? I mean, I guess technically you got to re-raise an objection at the time of trial. So I don't know if that's true in Massachusetts. In some states, you don't have to. I would have said it on the record right there. Your Honor, this did come in over our objection. We pre-tried it. Something. Because that would, even if they're wrong, that would put on the record.
Version, we provided a copy to the defense.
An effective assistance of counsel.
All the
if
okay,
they needed to do it.
Are you in agreement with this, Mr. Alessi?
Green is just me.
I haven't gone through,
fuck.
I have no reason.
Oh yeah, there's my big giant face. That's why.
Okay.
It says it's both of us.
There is
End screen.
well, admitted.
All right, I'm rewinding.
Actions that
Thanks, Tracy. I'm looking at myself. You'd think I'd know this.
In that version.
My Lord. Hold on.
Is it
I'm
game
gonna
on?
go back so Bob can hear this because it's short. We're gonna analyze it. I was talking over it, but first of all, I just want to note, Bob, when she gives her
this
ruling,
morning?
this is her ruling. Yeah.
Okay.
When she gives this ruling, I'd like you to tell me the difference between what he's allowed to say and what he's not allowed to say, because it means the same goddamn thing. And sorry, I shouldn't say that because there are religious people and that's not right. So good morning, Olivia. Olivia said, good morning, babe.
Good morning, beautiful humans. Good morning, Olivia.
All right, here we go. I can't take it.
Buddy. All right, so
not a surprise.
Dr. Welcher
right.
can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied.
Huh?
In addition,
Wait, let's just start there because she included at the time that reliable methodology was specifically on Shannon, whatever his name is.
All right,
So,
just play it. Let me hear it.
all right, here's the second one.
Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application.
All right, sorry, babe. Pausing there just to say we all pointed out they objected pretrial. They wanted to voir dire him. How
Pretty
the
big
fuck?
motion to keep
Right.
his ass out.
Right. So what I
Challenge his
said
methodology.
was, I don't know if in Massachusetts that you have to re-object at the time of trial, or say, objection.
I think it's always the safest bet
to object
just
again.
renew your objections.
Right. So I don't know if they didn't renew it, but I would have put on the record here, Your Honor, we did object. We objected pretrial. This came in over our
So
objection.
she's saying consistent with, though, right? Which is,
Yeah, he can say an identical vehicle of Mrs. Reed. He can say it's consistent with being struck with.
Consistent with, right?
Being struck with that vehicle. But here's what
it's
can't
consistent
say.
with is the language, though, that matters.
Yeah, well, with an identical vehicle to that of Miss Reed's. Okay, here's what he can't say.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admit.
Wait, can you just get me there? What does she mean? How is that? Which one's not reliable? How is this not reliable, but the other is here?
Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because
it's the same fucking thing.
Same fucking thing. What is she talking about? Why isn't she just saying it's a conclusion for the fact finders? He can't say that. All he can say is it's consistent with, like, this guy can't testify as to what happened because he wasn't there. All he can say is it's consistent with.
But saying it's consistent with,
it's up to the trier of fact to decide whether or not John. Because what Hank was trying to do yesterday was trying to say that this case isn't about a collision. Yeah, it is. Yeah, it is. That is actually what is at issue, whether or not there was a collision. Hank was trying to argue that there wasn't a collision, that the collision wasn't the issue.
Right. And I remember at some point this witness said, that is what happened. Something like that, right?
I don't know, babe.
But what I'm trying to say is, what is the difference between saying consistent with being...
There is no difference.
No, wait, let me finish. That the methodology is sound, to say that it is consistent with being struck, with John O'Keefe being struck by a vehicle identical to Miss Reed's, but the methodology is not sound to say that that Miss Reed collided with John O'Keefe. It was a vehicle just like hers was struck. But all right,
You're asking me to explain something I can't explain. I mean, we all listen to the same shit. It sounds identical to me. Like, I don't know.
And then here's the rest of it, because I don't get that.
Because that conclusion is not based on the application of reliable scientific methodology.
The thing that you're hung up on isn't even what I'm hung up on. It's the same methodology.
Right. That's what that is what I'm saying. So I didn't say
but
clearly.
You're not saying it clearly.
Right. I'm saying, how is the methodology sound to say one, but it's not sound, completely not sound to say the same thing differently?
Right.
In application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
Okay, so I'm just gonna.
I mean,
take it for what it
frankly,
is.
I consider it to be a win for Alessi. I mean, like he was, I mean, he was reaching a conclusion and wasn't saying that it's consistent with.
Right.
I mean, there's a
So
difference in the, you know, you need to.
there. So that's what I was gonna say, is that what she's saying, even though that the methodology is sound to say his injuries are consistent being struck with a, I'm just gonna say Karen Reed's vehicle because that's stupid, a vehicle identical to it. But there's no sound methodology to say she did in fact collide with him.
Like that part I can't explain because it's
Right.
there. It's the exact same methodology or lack thereof.
And then she says
there was no methodology.
right that he used
the only
other things.
methodology he used was to get rid of the time variance. Like that was a methodology. Whether or not you agree with it or not is a different story. But at least he showed his work. When it comes to the thing that matters, John O'Keefe, whether he was struck or he wasn't, there was no he didn't put anything on. Like there was no evidence. All he did was stand behind the car and roll off of it with blue paint. That's not fucking methodology. It would have been one thing if he would have stood back there and took the 24 miles an hour. Then I'd been like, you know what? I mean, the guy's all in. Like,
don't they do that, Obey, with crash dummies? Couldn't they have?
They could have. Well, and
thing?
here's the other thing. The thing, and I was talking about this morning with Allie. Here's what's going on. They are not going to address the taillight. This is going to be the Commonwealth's approach.
That you said that.
I figured it out. I don't know if Allie already told you.
I did, but you can say it again.
Well, then I don't need to repeat it. So
No,
I mean like
sure.
it's the traverse not causing the taillight damage by the way that they believe that they prove that, even though
they didn't prove
they
shit.
bought an identical make and model of Karen's car and they had all the data points. We saw them. We have millions of data points. We can do it. We can the 2 millimeters. So they have all that shit, yet they don't recreate the accident, the bumping, whatever you want to call it. Wouldn't that have been the best evidence if they have all that data to wherein they can, to the millimeter, recreate what happened, and they have Karen's exact vehicle? Why didn't they do it to prove that the taillight wouldn't shatter? Or
right.
Why didn't they do that? So they pretend like they debunked that, and now they're leaning on that. If not, then it had to be now. We don't have to prove it. Because if not, then it had to be now. That's their approach. And that's fucking bullshit. That is not enough to convict somebody in this country. I'm sorry. They provided no actual evidence. It can't just be by inference. Because look, here's what I'm gonna say. We got Alessi, and then we got the Arca boys. So I'm good with it. He didn't prove shit.
It's like they're trying to do a race ipsa loquitur thing with it.
Right. Exactly. That's exactly what it is.
Which is
exactly what it is.
In legal
speaks for itself. That's
exactly. So some cases when it's negligence, they don't have to show you file a claim under res ipsa loquitur to say, I don't have to prove exactly what they did that was negligence, because the only fucking way something like this happens is if someone's negligent. And that's what Bob's saying that he thinks that the prosecution's trying to do here. Well, it didn't break over there. So
The
we
thing
know
is, res ipsa only works in civil court,
right.
not
Right.
criminal court.
No, that's not
that
a
beyond a reasonable doubt thing. You know,
right. That's there. It's right.
that tricky little burden creates a situation where you can't use res ipsa in a criminal case. So
It's sticky. It's very sticky. And I was saying before you got on too that, him saying that the thing on the back of the car is the height of the eyelid, the bumper is the height of the knee. And I told him how you and I were both like, they don't even know how he was positioned, let alone that these two guys' knees line up, blah, blah, blah. And the arm hand thing, that all three of those, and I call that hand and arm one, could have happened in the same collision. Okay, it could happen with the eye being high enough. It could happen with the arm and hand. It could happen with the knee. How do all three of them happen at the same time, let alone all the other things about the explosion and the where the things are located and the glass and the plastic? Ugh.
all right, fire it up. Let's go.
All right. There's a little bit of talking here, so before the jury.
All right, so the jurors are lining.
Thank you for the late call today.
Okay. Is Dr. Welcher right around?
Yes.
Why don't we bring him in if he's here before the jurors?
Yeah, and tell him what he's not allowed to say. Thank you. I was literally about to ask that before we both sidetracked on ranting. I kind of want to pause and like brush my hair and
Well,
make
let it
myself
play
not-
while you're doing your shit.
No, I know, but I want to watch. Look like a dried rat.
No, you don't. Dried rat. You just got out of the shower. How could you be a dried
Right,
rat?
a wet rat.
You look beautiful. You're ridiculous.
Stated version, we provided a copy to the defense with all the redactions.
Okay.
The
Are you in agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I can just go away with anything else.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number? You don't have to find it if you don't.
It's 131.
Oh, was it 130? Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that. And Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was
Oh,
you were
now you
concerned
want
just
to get
about the
all up in
heading,
arms.
and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your Honor's recollection is correct.
Yeah,
I was okay with the heading removal.
And
I
we were
thought
going
it
to
was
start on that, but you thought because I struck it based on the objection, but then at sidebar, I said we could go back to that. That's your understanding too.
Correct, Your Honor.
And I'm sure that Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think he did as well.
I did.
Thank you very much.
Okay.
I would like your prediction to come true. Great.
Are they out there, Paul? Okay, thank you.
So, babe, I don't have.
You don't have court?
No, but I wanted it to be today because I need to get something continued. Or I got to figure this out.
Do we have blooping?
Oh, yeah, sorry.
Let's go.
Right, Mr. Brown.
We have a lot of blooping, so.
Oh, word. Love.
Yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first,
Hey, guys, let's just prepare for, as Amy Positive Pathways says, a bunch more of smoke and mirrors and lies by Brennan. All right, let's go.
is I'd ask you to turn to your PowerPoint, slide 110.
Is this the missing slide from yesterday?
Fuck, I got no clue.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide
I am out
130.
fucking raged. Why did they not object? That is a bullshit experiment. Did any you were able to hold your arm still because the car was traveling 1 to 2 miles an hour. So he stayed like this, tight the whole time. Am I in crazy world here, Bob?
No, that it's. I don't know why they didn't object to it either. I mean, they
they're gonna
obviously
be
saw
able
the video.
Right. They're gonna
I think that they're not objecting because it's as ridiculous as we think it is. Trust in Alessi. Trust in Alessi.
They'll bring it all out in
Yeah, it's going to all
cross.
come out and cross.
I just need to breathe. Sorry, guys. Here we go.
Please. To slide
I blooped it backward.
130, please. What? Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Sure. Thank you, Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you.
So we need to take this.
Sorry.
You could take the PowerPoint down, please.
That was in a different spot on the slide. Hold on a second.
That's fine.
Thank you. Sir, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Reading from something.
no, I am counting on my finger.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection where I matched up the heights, the locations of the lacerations, and then the tech stream data as well.
That information that you considered In addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with
What?
Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
With what?
Do you have an opinion whether,
With
based
what?
on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, and inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
Leading.
I'm going to allow that.
Mhm.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash.
We don't know
If the impact had occurred in the center of the vehicle,
if
and we knew where the point of impact was and
And
the
we
point of
knew.
rest, we'd have a much better chance of determining how fast the vehicle was
So
going.
we couldn't do shit.
But when you have just a corner clipping or glancing, it makes it more difficult to determine, even
My
when you
job.
have an area of impact, which is where the person was when they got hit, and a point of rest where they've landed, makes it more difficult for glancing contacts because you have that sideswipe problem where they don't obtain what's called common velocity.
Okay, so I couldn't do my fucking job. I don't know shit. Allie, look at this Massachusetts civil case. Caver. Oh, that was like earlier. It was like bigger. The little text.
Haver Carroll v. Christopher G. Simmons et al. From May 22nd or May of 2022. Case number Welcher was excluded in the civil case for the testimony he gave yesterday. Interesting.
Well, I surely hope that that's something that the defense found, because we know that they did their due diligence on, like,
and so co-mama, they can definitely bring that up.
Yes.
In
Yes.
cross. So here's what I was raging about when I was muted. So
you were muted.
he's allowed to sit there and say that at 8, as long as the vehicle's going 8 miles an hour, that the taillight would break. How in the fuck did he prove that? How is he allowed to just say that without any proof of what he's saying being true, without any methodology being put forth? Nothing. There's been no science. There's been zero science. After the data variance shit, this has just been more Ipsy Dixit. This guy's literally up there just saying shit without showing any work in terms of proof. All we saw was him rolling off a car at 2 miles an hour with paint on his arm, which is absurd. We know that didn't happen by what he just said, that it has to be over 8 miles an hour.
But he doesn't, like you said, he didn't apply any methodology of how he knows that. I mean, it could just be a, X minus Y equals, but he didn't say it, like velocity, force, but again, soft arm, and Julie Sriracha says, new motion to preclude the attempted use of any information not produced in violation of Rule 14. Which motion was this? By Brennan, or?
It's got to be filed today.
Yeah, but
it's got to be. No.
Barcelona. Thanks, Sarah.
Wait, where'd you see that?
Julie's, it's in the
new motion to preclude the attempted use of any information not produced. Yeah, it's got to be by Brennan.
House law to win a DD. Oh, we were supposed to do.
All right, I already did all those. Play it. Let's go.
Okay, wait. There was one other thing. About that.
Let's go, dude.
All right,
I want to hear this shit. He's rapping.
Rewind it. Okay. He was done talking, but I looped it back 5.
You have that sideswipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
So you never use crash dummies?
In your studies of direct pedestrian collisions by front or back bumper,
yesterday,
as opposed to
what?
We saw him with a crash dummy yesterday.
Yeah, but he's explaining why he didn't try to do this, like recreate the whole thing with the crash dummy, because they're just blobs. But you, sir, stood firm and taut and had your feet planted. He was like literally, and it only came 1 to 2 miles per hour at him. That's much better than a dead-weighted crash dummy. That's much closer to a highly intoxicated John O'Keefe than what the hell this guy was doing. All right, let's go.
direct pedestrian collisions by front or back bumper as opposed to sideswipe or clipping somebody.
You said the bumper
Is
hit me,
there a
asshole.
similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
Occupant?
When you see direct impacts,
Mean occupant.
is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
Yes.
No, it is not uncommon.
Bullshit. I don't
Have
believe
you had cases that you've studied or been involved with where
broken.
you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Bruises.
Yes.
What about bruises?
I'd ask you to turn
Scratches.
to slide 139, please.
Oh, I hate this guy.
Trust in Alessi.
Thanks, babe. I'll breathe
Trust.
again.
Breathe. Breathe. Oh.
Oh, sorry. I fixed those other two slides.
Thanks for telling the jury about that.
Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles.
What year,
I
sir?
redacted the name at the top. But this was an instance where we
Are you
had.
allowed to testify or not?
This is a image from the police report. Well, let me see if I can.
It's using a front.
So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact.
That tail light doesn't look shattered.
And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops.
Probably Bella's mom.
On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm.
Look at that bruise on his shoulder.
On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, Your Honor.
Do you want that expanded?
Does Scarlett have a game today, babe?
Tonight.
There you go.
Oh, I want to go visit Lila.
Yeah, no, my pleasure, Your Honor. Thank you. So to at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with
Breaks.
the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Red
Thank you,
marks,
Dr.
lower
Welcher.
extremity.
My
Your
pleasure.
Honor, I would move into evidence
That's
subject to redactions.
Tiny little.
Dr. Welcher's PowerPoint presentation.
Wow.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor. Thank you.
No, it's over my objection, actually.
In both the flash drive and the notebook.
On representation, it's consistent with the same set. I don't know.
So let's put them both together now and decide later.
Thank
Okay.
First spin on the wheel. Christine Silo.
Okay, so we'll switch that.
This guy got in some kind of like, he's got a splint on his ring finger and he's got this bruise on his head. Maybe he decided to take one for the team.
What
He
exhibit
took
number
it
is
at
it?
24
Right.
miles an hour last night.
Right? I just don't
Seriously, he's got a splint on his finger and he's got this weird big bruise on his forehead. Do you see that?
Did he not have it yesterday?
I don't think so.
He was out there getting hit by cars.
He's like, you know what?
I'm
I'm
gonna
gonna
do it.
I'm gonna
Just
do it.
gonna do it.
Get the tape recorder. Feel like get it all filmed. I'm gonna go out there.
Hey, let's say
Okay, go.
let's say hi to all the workers at Lutheran General Hospital, as well as Christine Silo's parents. Christy, sorry. Christy Silo says hi to her parents, her 3 sons, and all her coworkers at Lutheran General Hospital. Hello,
My 3
everybody.
sons.
All
Hey,
right.
what's up, y'all? Hopefully they're watching over there,
Yeah.
getting irritated like the rest of us. All right,
Okay.
fired up.
I have both screens up because we were rewatching him gently finger paint his body with the,
Allie, you're Shannon L's spirit animal.
Thank you.
206. Thank you.
Exhibits 206 A and B.
Huh. I mean, I can see it. Amy, positive pathways. It's scary.
All right, Mr. Alessi, whenever you are ready.
All right.
Let's go.
Time. Oh, I was like, which one of us is going to get to it first? Bobby beat me to it. So yeah, Amy says that she's in a mom chat, and some of these mom thinks this guy is legit, and the phone temp making them think maybe she's guilty too, and it scares her.
Amy, did they watch the first trial? And tell them you have to wait until after the defense is done. See if you're still there. Don't worry. Don't worry. They said
Streaming on Twitter, Mandy says. What'd you do?
yes. Streamed it on Twitter.
Oh,
I can see what the breakdown is.
okay.
We didn't lose anybody.
So this 2068 is both or just here?
Yeah, it's both.
Morning, Dr. Welcher.
We have the
Good
same.
morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert
Wow.
Alessi. Nice to meet you.
Nice to meet you.
What? Wow. Weird. Just saying.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law, yes.
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is.
Hello.
Are you familiar with NIST?
Comment.
National
That's on track.
Yes.
Yeah. So Would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process.
What?
The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
Or wait a minute. I mean, we've seen even the DNA people saying that after I get my come to my conclusion, I give it to this guy, even though it's like a kind of bullshit peer review. And at least someone in their own office peer reviews it. With that, why is he acting like there's no one else that could peer review his shit? Because
he's about to get peer reviewed during the defense's case in chief.
Yeah, Alessi's about to peer review his ass.
Arca's about to peer review his ass.
Arca, yeah, but Alessi too. All right.
So I think you may have misunderstood my question. So
Yeah.
I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry, sir,
to
to
get
interrupt
peer,
you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
Yes.
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
All right, he's about to he's gearing something up. He's lining something up. He's laying everything down. But I just want to comment on Mickey's
Laying traps.
Mickey's comment here. My Toyota experience and understanding is polycarbonate is designed to break into non-sharp pieces for safety. So I fact-checked Mickey with ChatGPT. Are polycarbonate taillights designed not to break into sharp shards? Yes. polycarbonate taillights are specifically designed not to break into sharp shards. Thank you for your knowledge, and you have been peer reviewed by a computer. You are accurate.
The robot says, you good.
All right. Loop back 1 second. Here we go.
Yes.
Okay, that was my question, just the
You
methodology.
finally
Thank
said
you.
yes.
You're
Okay.
welcome.
Let's go.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer
Without bias.
without bias.
Exactly.
Babe.
Do it with apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's when Alan Jackson would have said, so another way to answer my question was, yes, it's to avoid bias.
Bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what
What
you
was
can
that
do.
other sound?
That is the goal, right?
Someone
That
say
is
exactly.
one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And
Echo.
that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, this is, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you
Fair.
like.
That's
Let's
what we're
talk
talking
about
about. Sir.
confirmation bias. Now, confirmation bias is
Hey. Oy vey.
actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering
that you did.
alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Oh,
Isn't every one of the questions that you just mentioned
geared to the end one?
part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
What
But you would
happened?
agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case.
What were your
And then
many
as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Okay.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end, how do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen in the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like
Yeah.
I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
What are the things you
So
consider?
you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning.
I'm just going to pause it here. This fucking guy, I would be just wanting to explode. He is killing. And it says, I mean, that's his job, right? Kill the flow of the cross. But he just will not let Alessi get into a flow because he hems and haws over fucking everything. But I don't know if the jury's seeing it that way. So I'd like to know from you guys in the chat. And damn it, what was our poll yesterday? I never found out, Bay.
80-20 had seen the first trial.
All right. So we got at least 20% of you who are maybe less dug in than the rest of us. But I want opinions from all. Is this coming off like he's being, again, my favorite term for these fucks, an obstinate asshole, or like he's just answering the questions? All right, let's go.
No, he's definitely being obstinate.
But what's the jury thinking?
I think that they're thinking he's being an obstinate asshole.
Okay.
I mean, why wouldn't they? Because
that
like
mom's chat thought he was
the way that but they hadn't seen him on cross yet, because there's where you have the stark contrast of how he was on direct and how he is now when he's being cross-examined. I mean, it's night and day, right? I mean, he was a much different witness on direct. Now, maybe it has something to do with this giant bruise on his head. I don't know. Maybe he took a fall.
Is this it here?
What?
Can you see where I'm
I'm
circling?
gonna go look because
Can you see where my mouse is or
Andy
no?
said, like the last time he put up his hand, I didn't see the split. I'm going back. I know what I seen.
Right.
It
Just
wasn't a
let-
pen. It wasn't blue. He's got a blue pen in his hand now. This thing was silver on his ring finger. I'm gonna go back and find
Can
it.
you see where my mouse is circling or no?
You can't see it because his head's not turned the right way. It's on.
Okay,
his,
but
like,
I'm just saying. I'm just wondering if you guys can see when I do this because I'm on the
Yeah, I can see your mouse. Yeah.
because I'm on that screen, so I can't see what you see. All right.
Is that correct?
All right.
There are
Sorry.
prob-
The beginning, then toward the end of the analysis. Occurs more toward the beginning
Sorry.
than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking
The
about
answer's
the
yes.
hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning.
Right.
You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number
Windle.
of questions.
Sir Windle.
Maybe I can just this last question and make it clearer for you, sir. You would agree,
The
not
number.
analysis, which you added, as I heard it to the last part, just hypotheses.
Mhm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mhm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Thank you. God damn. Asshole.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Multiple hypotheses.
the one that most out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with
Yes,
some
science.
exceptions, that's a fair statement,
Yes,
correct?
science.
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper
Paul.
named Joseph Paul, Paul?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former trooper Michael Proctor, to be a reconstructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Correct.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get
What?
the billing or the statements.
Oh,
Wait, that's not what he asked, Pinhead.
well, but it was.
That's not what he asked.
He asked how much he was paid, but the point of his question was to do
No,
the
he
same.
stated how much he was paid. And then he asked him if it was to do the work similar to Trooper Paul's, which he said that he read the report. It was
Right.
one question,
All right.
in my opinion.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
Hell,
we're an
would-
engineering company. We bill for our time. So
you know that Aperture is getting paid for its work in this case, correct?
we are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume
Yeah.
that we're getting paid,
First,
but I
you
don't
better
know
be
that.
getting paid.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
Ugh.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid
You don't
before
get
the
on the
accounting
stand
department
though.
reaches out to me.
You haven't been paid.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth.
I signed it.
And you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
Part of it.
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture.
And is that then cost passed on to the Commonwealth?
No.
What?
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The obligation is the difference.
exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So
Wow.
the Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
Wow. No dog.
And
in
as
this
you
fight.
stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no,
What?
my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office.
I mean, but you said there's no
There's
dog
Mr.
in the
Burgess's
fight.
office, and there's my office in Long Beach. I only know about the billing from my office.
but you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection is
I think you got it,
you
Alessi.
signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you on it?
Yes.
May I put you on it?
Yes.
Thank you. Sir, may I
Yeah, could you direct me so we're not wasting time?
Wow.
Well, it's your, what I'd like to do, Your
Yeah,
with the
John
witness,
King.
Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
He's not Dr. Burgess. Is that what she just called him, Dr. Burgess?
I like it.
Lord, this is.
I'm surprised he didn't say, hey, hey, easy. How dare you, madam?
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor, thank you.
There you go.
Can I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh?
All
Or
right.
would you like me to start with
So-
refresh?
Go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore,
There's more.
and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation
Yeah, he said
that
that.
the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just
Maximum
does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
So it should refresh your recollection then, because you've seen it before. So that I don't get it. I don't understand what he's saying now.
And
He j-
we got started on this conversation tying it to, well, we got started on this conversation with regard to a
No
statement you
dog
made earlier
this
in your
fight.
direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
Because we all see that you did
You
400,000,
submitted an
325,
updated
whatever.
PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Come on, jerk.
The
God.
updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the
And
documents.
yesterday. At
Well,
the
was it-
Volunteer, wasn't it? 8
more
to 10
than
days.
3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Didn't he say on Vaudir yesterday, 8 to 10 days ago?
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yeah.
continue.
Or anything you can look at to refresh your recollection, just ask him, Alessi. He's trying to.
Are
pull it
you
up.
able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank you,
please.
Well. Oh, we got plenty of blooping time. Let's just bloop, 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 bloop.
Need for Mr. Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question.
And then
Mr.
shut your
Alessi,
shit down.
I need you over there. So,
Your Honor. Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
What
So
an
every day.
So
fucking
you've changed the
asshole.
presentation every day since when?
No, I don't think I've changed the presentation every day.
Oh,
That's
you
my
just said
question.
it.
My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago.
God.
So in response to various discussions,
How
I've been
many?
making continuous changes to it.
What an evasive piece of shit.
I want to make sure you finish your answer so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Great. So
Substantive change.
you
asshole.
created on January 30th, 2025. You made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yes.
January 30th, modified May 13th.
Right. If I could finish my question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings.
We're not talking about today.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
that was the second half.
Got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
No.
All right, so that's what I wanted to get to.
Jesus.
You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
Speak. I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
My God.
Did you
Instead of
consider
clear-
that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
Oh, so they sent you.
So a clip
or shit.
that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welcher, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me
and-
close it. Sorry. I was trying to answer his question.
Yeah, we'll use your goddamn memory.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just-
This guy thinks he gets to sit
Thank you,
here
Your Honor.
through his shit. What a
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
Who sent
What
it
was
to you?
the tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Okay.
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did
Oh,
you do
really?
with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative.
I'm sorry, this is
route
just
that
not
you
a big
wanted
deal to
look
me,
at.
what he's doing right now.
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
No, you're fine, Mandy. Someone had said before that our faces were blocking the judge, so I switched it over back and forth real quick just to check if the judge was there, but she's not. We're not blocking anything. If she's going to be shown on screen, everyone's going to see it. So wherever you want us is great.
Yeah, you can see her arm moving. That's
Yeah, you could switch us wherever you want us, Mandy.
I'm not blocking any.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that should be looked at. What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently.
Yeah.
I will, Your Honor. Thank you.
Confusing.
What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes.
What is that?
What he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial for your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people.
What about
I can
you,
only
buddy?
speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
So I'm just going to say because like with Love Jada says, I think he's trying to connect the changes with the Commonwealth backhandedly eliciting amendments. No, I absolutely agree. My only issue was like the new clip to me wasn't all that compelling. Like, all right, they found a clip that she gave a new possible path of travel, so he changed it. Like that one in and of itself was getting a little old. But yeah, no, this is all definitely important that the states eliciting these amendments, and who believes they don't just send you a clip and don't tell you what to do with it, for God's sakes. And on voir dire yesterday, he specifically said that Brennan had him taking stuff out and removing slides and changing things. So we'll get to it. It's just not.
Well, I think it's important. I don't think he needs to belabor it as long. I think he needs to move on. Because I mean, at the end of the day, this isn't where he's getting this guy.
Right.
I mean,
he's got to get to the whole time thing and the Ian Wickham.
Too much. He's a hired gun. I mean, I think the jury got that. Like he kind of got stuck in the mud there a little bit.
Right. But what he did yesterday, that was super effective. He's still got to pull all that out still, that he changed.
I just don't want to spend so much time kind of trying to chip away at, kind of the fact that they're hired guns and that they're apparently changing their reports constantly.
Yeah, but the change he testified to on voir dire is a huge point for the defense, that he changed the time based solely on what Burgess said, or Shannon said. I think I just pronounced his name wrong. And that the only that prior to that change, all of the volitional movements, there was a volitional movement of John O'Keefe that happened after the time that he had put in his report. Without that change, he would have had volitional movement after the time.
I get it, but that's getting into the specifics, which is what I'm wanting to get into.
Right.
Like, I mean, we're talking about generalities here.
Right. Well, this
guy, look, this guy is a professional witness. I mean, he's able to maneuver around
like a sleazy
all of Alessi's parries. I mean, it's like they're two fencing guys, and he's, so I mean, it's not his first time on the stand. Obviously, he's not Trooper Paul. He's handling these questions fine. He's combative. It may be making the jury feel a certain way. However, let's get to the good shit. That's all I'm saying. Let's get to the good shit.
You're welcome.
Mr. Alessi, is this a good time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks.
Bloop, bloop. We'll be right past this little break.
Hey,
Got our
Allison.
bloop. Blooping. I can slide my bloop. Wow. We're live. Should be coming back any minute, though.
What? Was a long ass break. Well, how long did we have?
Can you do that maneuver move again?
Me?
I forget which one of us did what. I mean, this guy is killing me. So we were looking at this. I'm just going to stick it back up here. I've got I can hear as soon as the trial starts, I'll hear it. Here's his little, I was looking to see, is he leaning in to get that eye near that top thing?
This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2-mile-an-hour impact. But even a 2-mile-an-hour.
Wait, where'd it go? Did I move? Okay. I think I moved.
Yes.
Up. Switching back, guys. They're approaching. Well, I guess it doesn't matter. They're approaching, so nothing. I can't hear anything else. See, look at him. Watch.
Yes.
Some ridiculousness.
Dr. Welcher, let me ask
Whether you're determine all that information. We have,
on a
of course,
question.
for your body travels. If you
Whatever.
have 1 foot on the ground, or
It was ridiculous.
It was ridiculous. Some would say ridiculous.
Ridiculous. A friend of ours in law school, she came up with that.
She sure did.
Bukaki?
Shout out to
Bukaki?
Stephanie Ripple.
Stuck.
Yep.
You can see the quarters in session.
All right,
Man,
whenever you're ready, Mr. Alessi.
Thank you, Your Honor, and if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
closed. Yes.
Would he open?
So it's just, did you just turn it off?
No, but I will. I close it. You like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm
sub?
going to see counsel at sidebar,
Sure.
please.
oh Lord. We're all plooped out. No plooping.
After years of craftsmanship
Oh,
and
things don't
timeless
happen.
style,
And I
our
get
leather shop is
commercials now.
closing.
I don't know. I got logged out or something, babe. You might have to take over. Who played that, Mandy?
I'm on it.
That's suspicious.
That is suspicious. That's suspicious as hell.
I don't know how I got logged out though.
I was trying to snarf on some popcorn
Hmm.
off screen, and I was rudely interrupted by that horrific break there. A little ad break. How did you get logged out?
I don't know.
Lunch break, I'll ask you to remove those monitors. Okay.
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break.
Thank you.
Okay. Thank you.
We'll switch it at the lunch break.
Oh, are you going to keep getting ads?
May I, Your
I
Honor?
think so.
Yes.
Thank you. Dr. Welcher, we left talking
No, I'm
about
just-
the
no.
amendments you made to your PowerPoint presentation. And in terms of
Oh, why don't
I'm pulling up. I'm not
Switch at
dealing
the
with.
same
I'm not
time.
dealing with ads.
the amendments you made to your PowerPoint
Text me,
presentation,
please.
and
boost it?
in terms of the amendments,
Is it boosted?
are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you
LTOP is breaking
aware
all edibles or
of
credibles. Well, at his, I'm going to say L.
activity
Mary.
in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not reviewing that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution.
Go to the mic, Alessi.
Might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is event data recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, event data recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Are you
asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me,
What
Your-
slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor.
That's right, fuckface. You don't get your computer open in front of you.
So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are...
can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that.
Are you saying there's no basis for the question?
Yes, eh?
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Alessi.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, that base, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that
don't.
there were do you recall that there was a report of Trooper Paul?
Yes,
Okay. And you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of
correct?
course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
All right. So I'd like to see Bob get a little more tailored to his questions. Like he'll start asking a question, then he'll think of something. Like he did that with that question right there. He was starting in on a question, and he's like, "Oh, yeah, I want to bring in the fact that he reviewed Trooper Paul's his report or reports, because what he's trying to nail him on this key cycle thing, which I saw a lot of chatter. It is huge. It's right. If it's right.
It is right. Wait, why? How are people saying it's wrong?
No.
I thought it was right. I think we've been saying that since day one, that these key cycles are off. I couldn't find my notes about it from last trial, but this was an issue.
See, here's what I'm worried about is that the jury's not understanding
Mhm.
the argument.
Right.
I don't know if key cycles have been sufficiently explained on direct because Brennan wasn't dealing with key cycles.
They'll tweak this at lunch. They'll tweak this at lunch so that they're sure it's carrying over with the jury. He just needs to ask the question again. Like, sir, I just want to make clear and use his exact, words.
Right.
If
But
the
I
trip,
also don't know if they know. Here, let me speak and then you take your turn because it sounds like you're going to be getting the same stuff that I'm getting into. I also don't know if they know what the significance of trip means in the context of what they're talking about. Because remember, I mean, none of this was brought up on direct. So like Alessi's introducing a bunch of terms where he's trying to get a Perry Mason moment, a gotcha moment here. And if they don't understand what the fuck he's talking about, it's going to be completely lost on them. So, I mean, I would have liked to have seen him ask him kind of a direct examination question. What is a key cycle? And have this guy spit it and then ask him, well, what is the trip? Because I mean,
I'm gonna look at
adamant because like Bob couldn't drive it home that point where he was saying, because obviously if you have a key cycle and you have trips that aren't lined up and they're taking place at a different location, like a completely different location, like somewhere either getting pulled onto a tow truck or somewhere getting pulled into the Sally port, and you can't obviously use that data. It's obviously all wrong data because you're mimicking movements of a vehicle when you don't have the correct location. So obviously it's all incorrect.
right.
Like if, for instance, the key cycle that we're talking about that we all believe is while the Lexus was in the control and custody of Canton PD was in fact when they backed onto the tow truck. If that's when it is, I mean, he has to be able to drive that home. And you know what I mean? He couldn't nail him down on the concept that if you have a key cycle and you're associating it to a different trip, meaning you're in a different location, you can't possibly give an accurate reflection of where that vehicle was or what it was doing. You know what I mean?
No, absolutely. And I think for lunch, we're gonna see what we can find as far as the Trooper Paul's key cycle graph from the first trial. But I think you're right. He does need to give them a better foundation of what each thing means and what trip means versus key cycle. So, because he's saying that the event is always with the right.
You know what I'd love to see here is a fucking killer chalk. I'd love to see a chalk like we saw for the glass.
Right.
Like right here. Because this guy, and I saw a couple people mention it in the chat and it was spot on. This guy is underestimating Bob Alessi in his he's thinking he's a typical lawyer,
right,
who doesn't really understand the technology. I'm the expert. This guy's a fucking lawyer. He doesn't know what he's talking about. He thinks
he's the smartest guy in the room.
Thinks he's slapping Bob around a little bit, correcting him constantly. So I'm really wanting Bob to really wind up like full throttle and come in and knock this fucking guy out. Because I mean, that's where this guy's head is right now. Like he thinks he's running shit. So I want Bob to get tighter. I want Bob to get tighter on this. I want him to get more focused questions because we know we can do it.
Kraken's grandfather-in-law was Perry Mason's brother, the man that created the series.
That's amazing.
I inherited all his original poetry pennings. Wow.
Wow, that's pretty cool.
Well, anyway, what I do think is going to happen is that they are going to spend all of their, like, I hope, their lunch focused on how to get this to the jury, how to ask the question away the guy's going to fucking answer and give the proper foundation for the jury so that they can have this Perry Mason moment. Maybe they are going to have to call back Trooper Paul. Like, if they can't get all this in with him, they're going to have to get it in as,
Well, they have to start at the basics. They have to explain to the jury what the terminology they're talking about means. Otherwise, it sounds like a bunch of gobbledygook. Like the jury's like, what the fuck is a key cycle? Like, I don't even know what that means. Like, it took me forever during trial 1 to really get a firm grasp of what a key cycle was. Like, in my world, it was like, oh, anytime I turn the ignition on. Well, that's not it. Like, you don't even have to turn the ignition on. As soon as you turn it in that first position, that's considered a key cycle. So it's like, I mean, they have to be made to understand what this stuff means in order for the points to hit home. Otherwise, it's just a lot of talking about things that the jury doesn't really get. Yeah, but we want to get them in the end, but you can only get them in the end, Marcy, if they understand what they're getting. like he may get us, all of us, the 80% of us that watch trial 1, and we know all about key cycles, and we know how critical we are, and we know that it was very obvious that Hank was avoiding them like the plague yesterday. We get that, but we're not the jury.
And Mickey says, thanks to the missing ring footage, we don't know that she didn't do a 3-point turning left to pull into the garage and align the vehicle. That's true. And
Sure.
Andrea says he doesn't know what to do without his laptop. He doesn't know what to do without being able to communicate with Brennan. I mean, facts.
100%. Yeah, I mean, you can see as soon as he
Farmer white hair.
When he didn't have his laptop in front of him, when Alessi was talking about he was going to a slide, he kept looking around. He's like,
I don't know what to do with myself.
What should I do? I don't know.
Well, because, as Farmer Whitehair points out, the truth is his third language.
I mean, look, this guy, again, is a hired gun. If people think he's going to collapse like Paul did, it's not happening. Like, Alessi's going to have to genuinely beat him.
Yeah. It's gonna have to.
Like, this isn't going to be, this guy's never turning into Trooper Paul. I'm telling you all. Bob's going to have to knock him the fuck out.
I agree, Louise. That thing drives me insane. That little reenactment that wasn't a reenactment.
May I, Your Honor?
Yes.
Hand painting in kindergarten.
Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
Yeah, started at
So
12:15.
There's 2 words, just strike theorized.
Okay. Thank you, Ronnie. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Alessi, the court reporter can't hear.
Thank you. I will.
I hope he started at 12:15. Who knows, though? He could be key cycle still. Either way, it's all good.
Go
You
ahead,
get
Not yet.
ask a,
Wait.
it's an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained.
Why?
You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
Why?
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry.
Yeah, let's go to sidebar because this is bullshit. I don't think there was anything wrong with his question. With based on the reports that you've read and the information that you've obtained, has the Commonwealth put forth more than one time that the proposed collision occurred or the alleged collision occurred?
What
Come
can the basis for that objection?
Come on, man.
Facts not in evidence.
It-
But yeah, he's asking because this guy should know. He might not know that the Commonwealth first said that it was 12:15. Then 12:45. Then they said it was 12:30. Then they said it was that. Then it's changed, and that's just the changes from the first trial. So we talked about this before about getting a stipulation, the judge to take judicial notice of the fact that and that's why I don't understand. They can't say a prior trial, but that the state has.
I mean, that cat's out of the bag. Like,
Right.
I mean, they let slip with that so many
The
times.
state's prior theory was that the collision occurred at 12:45 and then 12:30. Something. I mean, that you're not allowed to change your theory from one trial to the next. If they change their theory, the jury has the right to know.
Right. So the question then becomes, considering that the jury has the right to know that.
Hey, did you find that motion, by the way? I think.
I did, but
Go ahead.
and the issue becomes because technically they are facts and evidence, but it was evidence in a different trial.
And right now he's trying to get it into evidence. He's asking.
Well, he's trying to get it. He's trying to get it in through his review of Paul's testimony and report, or at least his report.
Right.
You know, I don't know what the actual basis for the objection is. I guess
He kept saying there's one word, and I think he thought it was alleged. He changed alleged to proposed. He changed theory because she did mention theorized first time, but it was theorized. It literally
theorized.
No, but it literally was the Commonwealth's theory of the case that the collision happened at 12:45, and then the collision happened at 12:30. Now the collision happened at 12:32.
All right. Yeah. Let me see. Trace, did you send me that? The motion that was filed?
She said, check your email.
Oh, yeah, I saw it on. Okay.
I mean, they're not allowed to do it, and the jury has the right to know that they've done it and that they're continuing to do it. So, I mean, they're over there figuring this out, how the hell she wants him to ask the question. And Brennan, just jump up and down all you want and turn your face red and pull your hair, but she sure as fuck better let him get it out. She didn't seem like she was.
All right, wait till you hear this motion. So 698, motion to preclude the attempted use of any information not produced in violation of Rule 14. Both the Commonwealth and defense are bound by Rule 14.
Whose motion is it?
It's the states, Commonwealth's. During the course of this trial, notably during Shannon Burgess's testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objections, unnecessary sidebars. and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony.
Well, that's a little late.
Yeah, that cat's out of the talking about like cat out of the bag. That ship has sailed, son.
Karen's taking notes.
Can't unhear that shit. Can't unhear that shit. But to me, it's funny that the defense is digging up things about the Commonwealth's expert that the Commonwealth doesn't already know in terms of a CV from 2 years ago.
Right.
Maybe Hank Brennan should have done his fucking homework. I mean, if Judge were on the up and up, she'd be saying, well, you know, I've got to be honest.
Have a guy lie in my courtroom.
Mr. Brennan, it was your witness. How do you not have all of his CVs, maybe from the last 10 years? You know he's going to get crossed on him. Maybe you should have had that to begin with. I mean, how does he not have that shit? It's what I was saying. I mean, Brennan didn't vet his witness. I mean, every lawyer that does trial work understands that when you put a expert witness on the stand, I mean, the CV is the jump off point. It's where you start attacking that witness. You're looking for fatal flaws. You're looking for holes. You're looking for things that you can nail them on. And for Brennan not to have done any of his homework, that's on him.
Wait,
I mean, like why does the defense have to come up with his old CV?
Wait a second. With Lyon's comment, if 1167 is testing, and I'm assuming that's Trooper Paul's testing, 1166 is the tow truck into the Sally Port. I thought they moved that car at some point into a different Sally Port. Did they not? Did it stay in that Sally Port until Trooper Paul did his testing? Do we know? I thought there was like one that was heated, one that wasn't. Maybe it stayed there the whole time. I don't remember. But if 1167 is the testing, and is that what, did they say that on direct, this direct? 1166 tow truck into the Sally Port. They had to drive it. What about when it comes off the tow truck? They moved it. Yeah. And wait, they also moved it. Wait, do we need back on that Lions thing? Because when they take it off of the back of the tow truck, they drive it into the Sally Port. So it gets turned on again. I don't know. But I know who does know. Right, 1164 was Paul's testing, I think. I'm not way up. I was reading what Lyon said. I was reading what Lyon said.
1162. If Lyon's right, then
no. But what they're saying is 1164 was Paul's testing. 1162.
But what I'm saying is, if Lyon's correct in what you just put up there, then Welcher's 1162 is what they were dealing with.
Right. If that was right, then it sounds like they are right. Now I gotta. We need to find the. Let me see. Hey, Tracy sent us the key cycles from the first time.
Yeah.
Oh yeah, 1167 is.
Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did.
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like,
Dude, the man always has to have something in his hands. What the fuck? Now he's looking for
I'm focusing on when you're trying
a calculator.
to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We're going to do that. We need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let
your
me
shit
know.
away.
Leave it right
All
there.
right.
So I just want to get
Jesus.
the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force.
That's what we actually measured.
Right.
In the
And
test.
can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you use the acceleration measured in feet per second squared, If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in Gs. People often heard about fighter pilots losing consciousness at 6 or 7 Gs, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or Gs as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not
Let's add the
getting
fourth
at the
bar.
manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
I mean, come on, buddy. It's your report.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want
No, leave your computer
to the-
down, sir.
That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document being referred
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why
Oh,
don't you show
Lord.
it to him, Mr. Lessie?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you.
My Lord.
Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yeah, from your
Yes, I did.
2005.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
What?
I believe that's correct.
It's 46 years old. Therefore,
Come
if
the
I did the
fuck
math
on.
correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It
What?
wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's about a source.
What?
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus
Shouldn't you know?
has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
You still have a sensor
I'll try it a different
for
way.
pedestrians.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number.
Jury's asleep.
You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
We're getting to something different, Jagoff. Man, Alessi.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
I think
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs
what he
would
asked you.
extend further, but I didn't have access to
You
the interior of the
assume-
house.
Oh,
The scene
so
was the
you
road.
didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I
Oh,
didn't want to trespass.
so you
Where
assumed
did
the
you
scene
understand
in the
the
street.
body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't
I don't know how that
access
body got there.
that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't
You have no
trespass
clue how that
and
body
stand
got
at
there.
that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes,
Then you know that there is a berm raised above street level, correct? If you did the scan.
correct.
Do you know the height of that berm?
I believe it's 4 inches.
How?
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So
What?
I don't know whether he was on the road or in the street.
Okay, so your
Excuse me,
whole
on the street or
testimony is
on the side of the road.
Exactly.
I just hate him, I hate him, I hate him.
Your depiction on
Yes,
your
they do.
slide, and you remember you had the ruler and you measured the height? Did you know
Absolutely.
that?
Yep,
Where was it? It was you? Was it you in that slide?
it was
Where were your feet?
on the ground.
On what part of the
Not on
ground?
berm, correct?
Correct.
Okay, so you chose the measurement, which was the ground, to the top for the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
You sure
Correct.
did, Farmer.
So, you chose to place Mr. O'Keefe in your
In the street.
simulation on the ground. You didn't
In
choose,
the
you
street.
didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground.
So you can't tell
which
this
is part
jury.
of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that.
It looked like you
So
did.
I don't have that information.
It sure
I'm
as fuck
showing
looked like you
the
did.
geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height matches the height of the laceration. That is one data point of many data points.
So
What a
you
fucking
would have to at
weaselly
least
little
concede
liar, dude.
that the level of his eye
Hmm?
could be non-contacting that fin or spoiler because you don't have information as you just described. Is this
Sure,
correct?
it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
No.
And you didn't take into consideration the
He's standing.
berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me
Oh,
two
Lord.
questions. I absolutely considered the berm.
No, you didn't.
And the second question, when
Pause
I
it.
presented to the jury,
No,
I
no,
mentioned the berm when we showed the
Pause
picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm,
Mhm.
I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so
What? Either
it's
hit
now
him or
it's a
didn't.
glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
It's everything.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
No, it doesn't, Dick.
I could probably find the slide for you.
Yeah.
So
Oh.
you didn't
Let me look.
do a force analysis to determine how much force would be applying, assuming a contact with the right eye, did you?
That's correct.
Why don't you do
And
that?
force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up.
Mm.
That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
Well, you know, at least 8 miles an hour. Let's
Mr.
assume
Alessi, why don't we
24.
break you?
Thank you, Your Honor.
So jurors, your lunch is here. We'll see you.
Oh, this is outrageous.
Goodbye.
So coming out of the sidebar there, like he just abandoned the whole key cycle thing.
Well, no, what he abandoned was how many different times did
He
well,
abandoned the entire key cycle thing.
well, the key
all
cycle
in the
thing
mix.
has gone away. I'm hoping it's coming back. But what he abandoned was how many times, different times, did the Commonwealth say that this happened,
It was all the
which-
key cycle stuff.
which might have also been tied to the key cycle.
What do you mean?
All right, you know what? I'm
You sound like
I'm
Elmo.
getting off real quick.
Well, it's lunch, so
Yeah. So I'm out.
what are you gonna do? Oh, she gone. All right. What do you guys want to do for lunch? What'd she say? 50 minutes? Is that what she said? All right, hold on. I got an idea for lunch. I like this guy's full of shit. There's no question about it. He will not answer a question directly. But I don't love the way that this cross is going. Like he's like getting into little debates with this guy. Like you can't do that shit. Like you have to be in control on a cross. Like that whole thing with the eye and the berm and the air wing or whatever the fuck you call that thing. He's got to take lunch, take a breath. I'm talking about Bob. He's got to get his shit tight. He's got to, like, when we get to the tail light itself, like, that's where he has to hit the home run. Like, all this other shit doesn't matter. Like, all of this other shit doesn't, like, this all boils down to the tail light. You can't get sucked into like a back and forth with this fucking dude, like we just saw. Like that was like two guys having an argument in a bar. That wasn't like a cross. Like Bob's got to regain control of the cross examination and just hammer him on the tail light. Yeah, he is. He is fresh. It's what I'm trying to tell you. This guy's a professional expert. This guy's not getting rattled. He's not rattling him. So Bob's got to beat him on the science. He's not going to get under his skin. He's not going to be fumbling and, losing words. And he's not Trooper Paul. He's a fucking professional witness who does this for a living. So that's what I'm trying to say. If anybody is expecting this guy to crumble, on the stand, it's not going to happen. He's got to beat him in his own game. Use that big giant brain of his. And the one thing that matters the most is the tail light. He has to have the tightest cross on how he used zero science, zero methodology in determining that John O'Keefe was struck by that vehicle and that tail light exploded. Because tail lights, when you like, how many of you guys have driven by an accident that's taken place in the middle of an intersection? Like the glass and the broken plastic is all right around where the accident took place. Like I'm not seeing glass 15, 20 feet away unless it was some high speed collision where two cars just plowed into it. So, I mean, he's just got to tighten it up. That's the way I'm feeling about it, because I mean, like, he just needs to get him into a position where he's going to have to admit that he didn't use any real science or methodology in coming up with his theory on what happened, that he gave zero explanation as to how he came up with 8 miles per hour is the speed in which a glancing blow would cause that taillight to explode. That just came out of thin air on direct this morning. He throws 8 miles per hour out there. I'm like, what in the fuck? So, I'm hoping we get some tasty cross after lunch. He'll reconvene with David and Liza and Alan, and they'll figure out the right approach, or he'll just sit quietly, like, which is what I would do. Like, I would just be, I'd be holed up somewhere for the next 50 minutes, just getting my shit tight, because he's certainly not getting his ass handed to him. And I'm talking about Bob, but he's not handing this guy's ass to him either. Like at this point, if this was a heavyweight fight, I'd have Bob winning on points by like 1 round, by 1 point, and that's okay. That's okay. I mean, if we're going to use a boxing analogy, then, Bob can just kind of match him for the first few rounds, but he's got to have the knockout blow with the taillight shit, because that's it. That's the whole case revolves around that taillight in terms of the Commonwealth. And if he can do damage there, if he can point out for the jury that this guy used no actual science in reaching his conclusions and his opinions, it's a win. Because the two guys that they have on the other side, because remember, this is really Aperture versus Arca. That's what this thing boils down to. You know, and we have the advantage on this side because we have a much smarter attorney that's handling the cross. Brennan's going to be overmatched. And there's not going to be a way that he's going to outsmart Wolf and Rensler. Whereas here, Bob can outsmart this guy and will and should. But we're going to have to wait until after lunch to see it. All right. I have an idea what we're going to watch until, what'd they say, 50 minutes? Okay. I don't want to find. Okay. I'm going to go back to the trial channel because I like them. They make it clean. It's clean over there. Broke all the shit down. Let's watch Rensler. Let's watch a little Rensler. We've already watched Wolf, so I don't want to replay Wolf. But I do want to watch Rensler if I can find him. Allie's yelling I should play Trooper Paul's key cycles. That's pretty good. All right. I think we've done this. This will make Mandy happy. We'll do the cross.
All right, Mr. Lally, whenever you're ready.
Good morning, sir.
Good morning.
If you could just again, please state your name and spell your last name, sir.
Yes, it's Trooper Joe Paul. That's Paul.
And sir, if I could just take you back to a couple of different portions of your testimony from Friday. With respect to the acceleration and braking tests that you conducted in the driveway area or outside of the Camden Police Department, was that before or after Ms. Hartnett from Crime Scene Services section had processed?
Projected with the body while he was holding it.
I thought you said on Friday, and you just agreed with me that people drop things.
Him asking all the physics questions and shit because we watched that. I'm going to try to get right to the key cycles if I can find that. Oh, wait, here's the scratches. All right, so this is a pretty good area to start.
To reconstruct it. Is that right?
Objection.
Okay, so there are lots of parts to that. Break it down.
Sure. Were you told by Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Trooper Proctor?
I was not.
Okay, next question.
Sure. Who were you told, who were you given your instructions by?
Instructions for what?
Reconstruct this incident.
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time who gave me the phone call.
And you were told some basics about that reconstruction, the event that you were asked to reconstruct, correct?
Yes.
The information that you were told came from the case officer. Is that right?
Who's the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident, pedestrian bicycle, motor vehicle motorcycle. You were told it was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that, yes.
All right, and you had to be given some basic parameters of what that incident, how that incident occurred. The car was going in reverse, it's got a damaged taillight, things like that. Right?
Some basic stuff, yeah.
What I'm asking is, I'm trying to get to is, who gave you that information? Where'd it come from?
That the car was traveling in reverse. Like, which part of the information? You asked me several different things just now.
Were you given information from multiple sources? Or did someone give you a summary of what you were being asked to do? At the very beginning?
Yep.
Who gave you the summary?
The summary of the whole entire, of what?
Of the event that you were asked to reconstruct.
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary, like, that I can remember. I was told that it was a pedestrian crash. I knew it was a Boston police officer involved, that this was the vehicle, and that it was traveling in reverse. That's all they had.
Okay. What I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
I don't know if it was definitely anybody from the get-go that was like I talked to.
From where?
I don't know if it's anybody that I could definitely say that was the person. There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on what the vehicle was.
Okay.
So
my question is this: when you got that, did you call it a lowdown? He gave you the lowdown?
He gave me information. Yes.
Right. When you got the lowdown, you were told Boston police officer was involved. The vehicle pedestrian incident, car was going in reverse, ultimately led to the death of the pedestrian. Struck the pedestrian in reverse, correct?
Correct.
All right. And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
I know the phrase, yes.
You know what it means?
I can't definitely say what it means.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
If you say so.
You noted in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to any other time?
I didn't have anything else on the time. I said that those scratches happened prior to this collision.
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, or I saw the video like a year ago on Court TV, I said that could be.
You asked the question, so next, keep going. He's answering. Next question. Then
You guys
go
how
ahead.
scientific
Hold on.
thought the scratches were.
Hold on. Ask
Sorry.
a question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes.
Bumpers get scratched myriad ways, correct?
Correct.
Get scratched in a grocery store parking lot, right?
Yes.
Shopping cart can bounce off the back of the car and scratch the bumper, scratch the side of the car, a quarter panel or something, right?
Sure.
I mean, I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get a scratch, correct?
Correct.
My question is, do you, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well, do you have any evidence whatsoever that you can point to that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second. Because
Yeah.
when you testified Friday, you were pretty clear. You said that, if I can find it exactly. You said, quote, the dent and scratches for his hand could be, those are consistent with striking the Lexus. Remember saying that?
Yes, on the tailgate.
Okay, so The dent and scratches you talked about on Friday, you said were from his hand.
Yes, hand in the glass cup.
Okay. Then are those the same scratches you're talking about in terms of the bumper?
No.
So,
What are you talking about? The scratch inside the bumper that we've been talking about?
correct.
Okay.
That's what I'm
No.
asking about. Okay. Is there any way to scientifically date a scratch?
No.
If you go out in the parking lot right now, even as an accident reconstructionist, if you walk out in the parking lot right now and look at a Toyota Camry sitting there, it's got a scratch on it. There's no analysis that you could engage in to date that scratch, could you?
Objection.
So you can ask it differently, Mr. Jackson.
Is there any way that you could, in general, look at a scratch and say, that scratch is from such and such date?
Objection.
I'll allow it.
Nothing more.
I'll allow it.
You cannot say. You can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would come from.
Right. And it's possible that any or all of those scratches on the Lexus could have predated January 29th, correct?
No.
That's not possible.
The ones that are on from the taillight and the other parts of it.
Scratches anywhere on the car.
Depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch, it's possible that any or all of those scratches could predate January 29th. It's a simple question, right? It's possible.
You're being pretty broad on your scratches here.
I'm not being broad. Let me ask it a different way. Let me ask it again. Is it possible that any or all of the scratches that are noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car
Answer that question.
that it predate.
Objection.
I don't know every single scratch on that car. I could mean
Overruled. So can you answer that question?
no.
You testified that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, could be matched to the cup?
I don't know anything about that. I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup, that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's what was told to me as evidence
Got it. By whom?
by the crime scene.
Who told you?
As crime scene that was there, it says it's glass from the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. No, yeah, I said by crime scene. While I was at my inspection.
Wait, what?
It was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Did Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No.
Just the crime scene told you.
Correct.
But if you knew that the crime scene was incorrect, and in fact those glass pieces don't match the cup, would that change your opinion?
Objection.
Sustained.
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No.
I'm sorry. No, you
I don't. It's a glass from a cup. It's a glass. It's not. It doesn't belong to the vehicle.
Right.
It's glass.
But if I told you it didn't match that cup,
What?
Objection.
Does that change your opinion?
Are we talking which cup? We never established which cup we're talking about.
How many cups have we been talking about, Trooper?
You said that cup. One at the, from the scene. Okay.
That cup. I'm talking.
I just want to make sure that we're on the clear path here. On the clear what we're talking about.
Absolutely.
Okay. All I said, it's
found next to John O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
Yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup. It's not glass from the car. That was my opinion on it. I never said it matched to the scene.
You didn't.
I never said that in my thing. I said it's glass from a cup.
Okay. It's safe to say you didn't do any testing to determine the forces necessary to shatter the taillight on a 2021 Lexus 570, right?
I did not do testing.
Your report indicates, we've talked about this a little bit. I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came into his final resting place about 7 feet from the roadway, and that's what you based your diagram on, correct?
Yes.
Who told you that number?
I measured it from my diagram.
You should say that again?
I measured it from the diagram.
Okay, what I'm asking is how did it get on the diagram? In other words, who told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant, was it Gallagher, Paul Gallagher, Captain PT. He told me this is where the body was found. Okay. So I used my devices to mark that location.
Okay, but before you used your devices, he just pointed someplace on the ground and said he was about here, correct?
Yeah, that's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did he say that?
No.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body at being approximately 15 to 20 feet from the roadway?
No.
If he had told you that it changed your diagram?
Objection.
Overall.
He told me this is where he's found. I marked that location. That's all that was.
And you marked basically every other piece of item. Sorry, that was a terrible question. Every other item you marked based on a distance from where you were told John O'Keefe's body came to rest, correct?
Yes.
Yeah, and that was by Lieutenant Gallagher just pointing at the ground and saying it was about here.
Correct.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
What do you mean team? Canton PD?
Whoever was there. Who was there with you when you started doing your measurements, et cetera?
I said Lieutenant Gallagher. That's who.
Just you and him?
And myself, and I was training a trooper at the time. She was there.
You were training a trooper at the time?
Yes.
Okay, so it was my mistake. I assumed that there were several people out there. Just you and Lieutenant Gallagher?
Yes, that's why I was confused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place?
No, I don't think so.
You did document in your report that the items that you noted on your diagram that we just looked at a few minutes ago, those were found by the CERT team, correct?
Yes.
And you indicated in your report that the members of the CERT team located a single Nike sneaker that's noted on your report. Is that right?
Correct. Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a taillight was discovered.
Yes.
So your report is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well, it was that on there. I can't remember if that's on their diagram or if that's what I was told at the scene, but yes.
Sure.
Yes.
You knew that a cup was found.
Yes.
Or you were told a cup was found.
Yes.
And 3 pieces of plastic, 2 red, 1 clear.
Yes.
Not 5 pieces of plastic, correct?
Correct.
You then measured those items, is that right?
I didn't. What do you mean measure them? Like
Measured
at
them
this?
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it. We're going to go over those numbers.
Yes, I used their report to place those items onto my diagram.
So, I'm going to get to that question in just a second. I want to make sure that we walk through it sort of methodically. You then use some calculation, some tool or something to measure distances. Like there's where I assume John O'Keefe's body was. Here's a final rest place. I'm going to use that as point A, and then I'm going to measure from there and go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes.
Who told you where the pieces were found?
They were in Lieutenant Tully's report. He put measurements in his report.
Okay. And you noted that the shoe was 9 feet.
Yes.
You put that in your diagram.
Correct.
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
Correct.
1 foot is about that long, right?
Yes, it was. They basically said it was found next to him.
Right.
Yes.
A piece of red plastic 7 feet from John O'Keefe's body, correct?
Correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes.
And a red plastic piece 12 feet from John O'Keefe's body, correct?
Correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from. He just said he was here, so I tried to put like where his head, where his feet, and try to measure the middle between those two.
So ultimately, because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
You had no photographs of John O'Keefe in place, correct?
Correct.
There were no establishing shots, and there were no perspective shots, correct?
Correct.
There were no relative shots, meaning this is relative to that, I can measure that and figure out distances, correct?
What, like from a picture?
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2 or 3 or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure from there.
Sure.
You get cross coordinates, right?
Sure.
Left and right, and where the 2 coordinates match, that's where the item is, right?
Correct.
None of that was done, right?
From the pictures?
None of that was done to do your measurements.
I use, like I said, I used the measurements from. I measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Objection.
Did you guess?
I did not guess.
Next question.
You stated in your report that you Google mapped Miss Reed's path of travel. Well, let me ask you a different question. If I could withdraw that question with the court's permission.
Yes.
Your diagram has all those arrows pointing at specific locations. Very, very specific. Very thin arrows point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well, wouldn't it?
Objection.
Is that true?
I mean, I guess hypothetically, depends on how off you want to be.
And the answer is yes, correct?
Hypothetically.
You stated in your report that you Google mapped Ms. Reed's path of travel on January 29th based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the two events, meaning the triggering events, occurred at the same time the Lexus was at 34 Fairview at the time of the collision, correct?
Yes.
The first triggering event was what? Was it a 3-point turn or a U-turn? I thought I heard you say both.
I guess it would be more, 3-point turns, essentially. I guess it's a 3-point turn.
Okay.
Yes.
Well, did you say U-turn on Friday? I could have sworn I heard that.
It could have been a U-turn. I mean, it's still turning around. So you had to make a U-turn when that's a 3-point turn or not, but it's still.
Okay, but I mean, not to be picky, but sort of my job.
Okay.
A U-turn, traveling in one direction, turning, right? Turning the wheel, never changing gear, and just reverse or anything, just turning, right? A 3-point turn requires moving forward, stopping, changing gears, moving backward, stopping, changing gears, using a steering input, and then moving on, correct?
Correct.
Well, those are two very different maneuvers, right? You'd agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. It's a 3-point turn. They're still making a U-turn. And it's, I didn't mean it as like she literally had to make a direct U-turn. She was turning around. And obviously the diagram, or the trigger shows a 3-point turn.
Well, I mean, I guess you could have said reversing direction, right?
That could have been a better way to say it, yes.
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn?
It's a 3-point turn.
Okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's correct.
So when you said U-turn, that was inaccurate.
Objection.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? Starting point and an ending point? Tell you the exact path Lexus traveled?
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map, and Trooper Proctor told you Lexus traveled from point A to point B, there are multiple ways to get from point A to point B. You'd agree with that, right?
Yes.
You picked one of those, right? The path of travel includes freeways, et cetera, right?
Yes.
But as you sit here, you don't know what her actual path of travel was, because it could have been something different, right?
It could have been something. That's why I gave a range on my diagram.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
I got the addresses from Trooper Proctor. I put them into the thing, and then one of the possibilities of 36 miles, and that was after looking at all of them, at 36 miles is a possibility.
Right, understood. So that's what I'm trying to get to, Trooper Paul.
Okay.
That's one possibility. There was 36 miles,
Mm-hmm.
one route of travel, right?
Correct.
There were other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of had to guess. And there's no science to it. You just said, I'm going to pick that one and put it in my report, right?
No, that's not how that worked.
Okay, why don't you tell me how that works?
Her odometer mileage on the car from the download and the time we had the vehicle shows 36 miles. So when I plugged those addresses into Google, it came up as 36 miles as a possibility.
And you knew that there was another route of travel to the same location, correct?
What do you mean?
there were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from Ms. Reed's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to do cell phone extractions.
So that answers my next question. You did not even attempt to do that, did you?
No.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Locker, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycles to turn the accessories on.
All right. But it doesn't, my question was, and where we started with this conversation is, it does not have any location data on it whatsoever.
Correct.
All right. So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them, key cycles.
By key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
It doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, I'll try to be tricky here. Seeing triggering events, your car's in motion, what does that tell you? The ignition's on or off?
The ignition's on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not to report the difference to you, correct?
On the key cycle,
Right.
On just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay.
Did you testify on Friday that this is a copy of the exhibit that was put in 591? This is part of your report, correct?
Yes, it is.
And this is a chart that shows when move to this arrow. That arrow indicates top and bottom where your testing occurred, correct?
Yes.
And you move over to the left. That is key cycle what?
1164.
Right. So you've testified, and we can turn the lights on. Your Honor, I don't mind if that stays up. We can turn the lights on. I don't think it hurts anything. You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1164. Is that right?
Yes.
Okay. So what you're saying in that report is The triggering events were at 1162, going in reverse, in order. 1162 comes before 1164. They're numerical, is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right. And you knew, and you put in your report, or you know, that the triggering events that you see under 1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were two key cycles before that.
Yes.
Meaning ignition cycles, at least, right?
Yes. There were 2 key cycles. That.
Stated in your report, well, let me finish one other point. You said that the mileage difference between these 2 triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report. I think you mentioned Trooper Zach Clark. Is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini. Is that right?
Yes.
Also, Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess it's now a 3-point turn, right? Changing direction, and then
Yes.
the reverse at 24 miles per hour, correct?
Correct.
And you even went on and testified to that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. Under the text streams?
On the key cycles.
Not in grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
If your testing occurred at key cycle 1164, that means you turned the engine on, the ignition on to start your testing, correct?
Correct.
And that triggering event that we see up there at 1164 initiated your testing, is that right?
Yes.
All right. So that 1164 is where that's where there's no more unknowns, in other words, right? You know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were and what they reflected, because you did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis of the key cycles.
Say again?
The cornerstone, in other words, the one known that is immovable, it's immutable, is 1164 began your testing. Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right. So starting at 1164 and counting backward, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't speak to the fact that we record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
Trooper Paul, you just said unequivocally, when a car is turned on and then turned off, there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I mean, when it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why it didn't go on, why it did not record.
Well, let's talk about the ignition cycles.
Okay.
Before 1164. Okay?
Okay.
Obviously, the car had to get to Canton PD because you saw it there, correct?
Correct.
Assume for purposes of my question, the car was turned on, and there's a video of it turning on, driving up onto a flatbed tow truck.
Yes.
That would be ignition cycle. I'm going to use your word, key cycle, ignition cycle, 1163, correct?
Again, ignition cycle, key cycles are two different things.
Which word do you want me to use?
If you want to talk about key cycles, key cycles. You want to talk about ignition cycles, it's ignition cycles when its vehicle gets turned on. A key cycle does not mean to be turned on.
But every single ignition cycle includes a key cycle. You can't have an ignition cycle without a key cycle, correct?
Well, if you want to talk about it, just use the key cycles or ignition cycles. I'm trying to make sure this gets out. I'm trying to make sure that this gets put out the correct way.
Every ignition cycle includes a key cycle, correct?
In a sense.
By definition, it has to, right?
It doesn't have to. They record multiple different ways.
You can have an ignition cycle without a key cycle.
I don't know how it recorded, but it could happen.
Explain that. How could that possibly happen?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so.
Or the 2 seconds, if it's not on long enough, it might not record one.
Okay, let's ignore the 2 seconds.
Okay.
That's not what we're doing.
Okay.
All right. Let's assume that it's an old-fashioned type of key.
Okay.
Halfway on, the electricity is on. It's like it used to be called ACC.
Yes.
Right?
Yep.
That's a key cycle, correct?
For that intensive purpose, yes. This vehicle's not a key cycle. They're not a thing.
Keep turning,
Okay.
and that turns the engine on, right?
It turns engine on, correct.
An ignition cycle, right?
Yes. Well, then turns off.
Ignition cycle necessarily includes the precursor key cycle, correct? Even though every key cycle might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine. Okay, with that definition, I want to talk about ignition cycles because I don't want to get confused about accessories. Just assume the engine.
Okay.
Right?
Okay.
If you started your testing at 1164, then if the engine was turned on, thereby indicating initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163 in that hypothetical, correct?
It could be.
Okay. Then going backward from there, if the SUV was, I'm sorry, let me add one event that I just forgot. It had to get off the tow truck in Canton and be driven into the Sally Port. Did you ever see that video?
No.
Being driven in?
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be a key cycle, correct?
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto the flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going back.
It's possible.
All right. Before that, if the car was started and the car was driven from One Meadows Avenue to Karen Reed's parents' home in Dighton, that would be another key cycle, 1161, correct?
They're possible.
Before that, if the SUV was started and driven by Miss Reed from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Is that right?
It's possible.
And before that, if the SUV was started and driven by Miss Reed to the waterfall, from the waterfall to 34 Fairview at approximately 12:15 a.m., that would be another key cycle, 11:59, right?
It's possible.
I want to be clear. The reason that these numbers skip in your diagram, they don't go directly in order, right? Not every single number is in order on this left-hand column, because this is only a diagram of when triggering events occur, right?
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 11:59, driving over to 34 Fairview from the waterfall. Then driving at 5:07 in the morning over to Jen McCabe's house, 11:60. Then driving to Dighton, her parents' house, 11:61. Then the car being seized in Dighton by Trooper Proctor, 11:62. Then the car being taken off the flatbed and driven into the Sally Port at Canton, 11:63. Your testing starts at 11:64. That would mean that at 11:62, that key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical.
Your hypothetical?
Yes.
If that's hypothetically how it works, then yes.
Then what?
If that's hypothetically how it works, then yes.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel if struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You were asked, does that remind you that you were asked by a grand juror if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would be based on miles per hour and stuff. Did you ever do any stuff to test that? The grand juror's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
Me. The role me.
Well, you know John O'Keefe's weight, right?
What's that?
You know John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Okay. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jurors that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified, again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
Yes.
Got only fan on the other.
It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle throw formula.
What formula?
Searle.
What does that mean?
It's a type of formula that we use for a calculation of post-impact or speeds for pedestrians.
That includes certain principles of physics to calculate that, right?
What do you mean?
Sorry?
What do you mean by certain forms of physics?
There would be physics calculations that would be required to figure out how far a body at rest would move having been struck by an object in motion. Right? That's a basic principle.
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel having been struck by an object in motion?
So in this scenario, in this collision, it's more of a sideswipe. So he did not ascertain, he did not get enough speed of the vehicle post-impact with the vehicle to be able calculations. His center of mass was offset from the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, he would have been able to get more closer to the actual speed of the vehicle during that post-impact travels.
Well, that presumes a couple of things, Trooper Paul. That presumes that he was quote unquote sideswiped, right?
Anybody know?
Presumed?
Presumed by you. You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a sideswipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
It's the calculations that are out there. You can get a speed, it will just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference.
Okay.
Right? Did you agree with that?
No.
You wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, in that sense, are we talking about trying to find the speed of the vehicle? That's usually what we're trying to do.
Right, okay. Well, let's put the speed of the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there is a
So sustained. Ask it differently.
Isn't it true, Trooper Paul, that there is a singular calculation for determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow magically out of the realm of physics?
Objection.
Sustained.
Is a pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes.
Got it. Where'd you learn that?
It's in my math class. We don't use momentum for a vehicle to vehicle.
Math class?
The crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Conservation of momentum.
Yes.
You know what that is? There's an equation for that as well, right?
Yes.
You know what that is?
Not off the top of my head, but yes.
Based on the basic principles of physics, is the total momentum of the collision greater or less than the total momentum after the collision? Total momentum before the collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Paul, they're exactly equal in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's transferred from one body to another.
Yes.
Correct?
Correct.
Why didn't you say that to the jurors?
Objection.
Sustained.
Trooper Paul, if you were qualified to, quote, look into all this stuff, you would probably know these answers, wouldn't you?
Objection.
Sustained.
Are there any other calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
How about calculating the final velocity of the objects after the collision? Would that be important?
What objects?
That would be John O'Keefe's body, sir. The object that you claimed was flying through the air 30 feet.
Objection.
Sustained.
How about calculating the displacement using kinematic equations? Would you be able to do that?
The displacement of the body?
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic equations?
So like I said before, the Sideswipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You couldn't hit a person and Sideswipe them, spin them off to the side, and have that and get a speed from those calculations.
So you're saying that the discipline of physics cannot figure out how far John O'Keefe's body would move, but you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
Sustained.
Are you saying that the principles of physics are incapable of determining with the proper calculations how far John O'Keefe's body would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No.
Okay, next question.
Well, you just said because it was a sideswipe, all these calculations, these physics calculations are inapplicable, right?
I'm saying it would underestimate the speed, the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes.
You have been.
It's incorporated into the classes.
Right. You had a few classes that use the word physics, but you haven't been formally trained in physics, have you?
Objection.
Sustained.
You haven't been formally trained in kinematics, correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated emission cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson, ask the appropriate part of the question, you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, what do you, it gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm on a hinge? Was it in front?
Go ahead, Mr. Alessi, whenever you're ready.
And we're back. All right. Speak in your mic, Bobby.
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on any
bones are
bone.
on the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Oh,
Now,
God.
given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is either from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Get behind the mic. Get
Go
behind the mic.
So let's take a scenario where it's a center of impact.
Center of mass.
Center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
He's doing the maths. Yeah, I was doing the maths. I'm really good at the maths. Just postulating theorems, formulating equations. I'm about the same level as Trooper Paul when it comes to physics. Huh? I need more information. That would have been my answer for everything. Maths ain't my shit. Maths is not typically, most lawyers I know are not great at the maths. It's true.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic application of the numbers, correct? You divide.
Correct. We're doing a little simplification in terms of the crash
Yes.
pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, the F you would get to have to cause a break at the occipital bone. Do you know from the this is how much pounds of force you would get to have to cause a break at the occipital bone? Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your
Is that Allie? Allie, is that you? Off screen.
Oh, I was like, babe, pause. And then I was like, this asshole wouldn't pause. So I just took over. I didn't realize I was off screen. I'm like, why is he ignoring me?
Wow.
So yeah, I took over the controls, but I did think you were ignoring me. So I just want to know when we came back, because I'm sorry I had to take a client call. Did he start? Is he back on anything like
No, he's starting with the tail light.
All right. All right.
He's got him doing maths now.
Okay. I don't know if we
Remind
had
me
this
of a
many.
couple because you fucked up the whole flow of the math
I
problem.
will. I will. I don't know if we had this many people for Trooper Paul, but I was on here a little bit for that and trying to pay attention. I mean, if they've got the whole time fucked, they've got everything fucked. So hopefully he comes back to it, or maybe they are going to call Trooper Paul. All right, here I backed it up. Here we go.
I think they're going to have to call Trooper Paul.
They might have to at this point. All right.
force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you?
Mm-hmm.
We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals?
He's like, uh-oh.
Correct.
I knows math
How much
and
pounds of force
medicine.
do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to
Come on,
break
buddy.
a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
I'll go read
Not off the
that
top of my head,
literature.
no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
Contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right?
But let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testified to on direct. You don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the tail light, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers.
Okay.
Okay. You said 300 and 750. Did I hear it correctly?
You did?
Okay. That's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350.
300.
Above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds. So you are
Still 1,000 some pounds
1,412 pounds
over the force
above
needed to break.
the force required.
To break.
Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of the this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was the, you said,
2,180
you said dyslexic? Or
No.
did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force?
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Alessi?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide.
Oh,
Don't
sure.
tell
Here
me.
instead of
I'll
just-
tell you.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the 2 body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis.
Oh, they have the lights dim.
For the hand, no.
What
But
about?
you did it for the head, correct?
Correct. Because that I'm able to quantify.
You just quantified it.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
track.
Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you.
Look, he's still checking his
You
map.
are aware,
Yeah.
Dr. Welcher, that
What's he
Mr.
doing?
O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report. but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
What?
Other than the occipital bone or the skull?
From the compressions.
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Scorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Scorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
You asked me about the opinion of a medical examiner. I'm not a medical.
Only one person.
Yeah, shut up, buddy.
Mr. Alessi, let him finish. And then
Mr. Alessi, let him finish. Alessi was talking.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam.
I understand, and I think I've been doing that, but I'll redouble my efforts. Dr.
Redouble
Welcher,
those efforts. You too, Jagoff.
my question. I'm going to repeat the question.
Mhm.
Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Well, that's a point there because they didn't take an x-ray of the hand, of the arm. Or wouldn't there
Do
be a
you
bruise if they're breaking?
understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Scorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
So far, the only question is he aware of any analysis? But
everybody hates this guy.
Yeah, but you know what? Technically, you can get a hairline fracture without a bruise.
It's true.
So, ugh.
It's true. I mean, him just opining it.
I feel like there'd be swelling. There'd be something. I mean, I don't know.
Like I'm having a hard time trying to put together why he was trying so hard on the hand thing. I mean, obviously, in this guy's theory of what happened, you know, the arm, the glass, holding the glass. See, that was the thing that Bob should have asked, because the hand surface wouldn't have been flat. Because if John was holding the glass, his hand would have been curled around the glass. So as far as the displacement, because if I took a 1,000-pound anvil from 5 feet and dropped it on my hand, it would crush my hand. It would crush the bones of my hand. It doesn't matter if it's displaced. So I don't know. I don't know. I don't know how this is going. It feels like a stalemate to me.
Yeah.
That's what it feels like.
Yeah.
Like, in all honesty, it just feels like a stalemate.
I hate that they didn't take an X-ray.
Yeah, but I mean, are X-rays normal?
Well, maybe they're not, but they're assuming that he was hit by a vehicle. I feel like, I mean, I don't know. I guess it's not. I mean, no, maybe it's not normal, but you can't rule out the fact that the man had a hairline fracture without the X-ray.
Yeah.
Like, so
I mean,
here's what I think.
Here's where I'm. Go ahead. Here's where I'm worried, and when I say worried, I'm just talking about in terms of the jury as to this guy. Like, he's coming off like again, we all have formed an opinion on this case.
Right. We all hate his face.
Right. We can't stand this guy. You know, it's like forget about that for a minute. You always have to think about these cases in terms of what a jury could be perceiving is going on.
Right. And the comment we had earlier from, I forget who it was, that she's in a mom's group, that they think he's legit.
Right.
But like you said, they hadn't seen Cross. Sorry, go on.
So, I mean, he's combative, but he's not flustered.
Right. And he doesn't sound wrong.
And he's fucking calculating shit on his calculator up there. And, you know, he's coming up with answers. He's seemingly correcting Alessi. And the jury doesn't know whether or not he's wrong.
Who's right? Who's wrong? Right.
Right. I mean, for them, it's like, all right, this guy really seems to know his shit. So when Bob continues to try to drill something home for an extended period of time, and the guy's just, he's like, Bob's not able to stop his forward momentum. And
right.
Bob has not taken control of this cross in a way that
he's getting the momentum.
Right. Like, where he's batting this guy around a little bit. You know, it's like this guy. So I'm saying, I mean, to me, it's a stalemate, but a stalemate's in the big picture, not a loss.
Right. And you still have Arca.
The entire case.
Arca can speak to all this stuff. Right.
Well, I mean, that's like, that is the ace up the sleeve, is that we have two guys that.
But the jurors are going to have to be thinking like we're all thinking. You can't tell me that car hit that hand at 24 miles an hour and didn't, well, break a bone, but now we have, did it possibly break a bone?
I don't know. That's not necessarily true.
Or leave a bruise, I guess. I mean, I'd be You
No,
bullshit.
not you, babe. I was saying to Ann, she was saying it's cross, defense needs to win. Not always. I mean, trials are it's ebbs and flows in trials. You know, you're not going to win every cross. You don't need to win every cross in order to win a trial. That's just not how this thing works. If they could kind of keep this guy at bay, and have the jurors use some common sense as to, you know, what they think in their mind would happen if a 6,000-pound SUV hit a dude's arm. You know, I consider that to be, like I said, a stalemate. And then, you know, would I feel comfortable if I were the defense not putting on any evidence? No, but we know that's not going to happen. I mean, what we have is two highly qualified guys from ARCA that are going to be able to speak to what this guy's saying. And worst case scenario from ARCA is that Welcher and ARCA, and this is worst case scenario, X each other out. So then you're left with everything else that the Commonwealth has put on, which has been nothing. So if you can keep this guy to where it's just like a draw. I mean, look, I want to see Alessi knock him out. You know,
I want to see some of that.
Maybe it comes with I'm hoping that the last area of cross is going to be the explosion of the tail light, because that's the thing that I think is inexplicable.
Not explained.
It can't be. It not only has it not been explained, it can't be explained by his theory, which is why he didn't try to do it. I mean, when you have a gaping hole like that with a fucking egomaniac like this guy, if he had a way to explain it, you have to know that he would have.
Right.
So
but,
he
you know, like Mickey points out, the jury frustration could carry over to Alessi, and that's not good or needed. So I think what Alessi was trying to establish, both with all of this, like when he started with the head, and you did this with the force of the head, that he was going to get at the fact that, okay, but if you add the force of the vehicle, not just the simple fall, like you did with the dummy, but the force of the vehicle, that you'd expect like even greater damage to the head, sort of like he's trying to do with the hand and the arm. And now you got like his hip touched the car enough to scratch it. You got to have a bruise from that, right?
I would think
That his little metal thingamabobber scratched the car in this scenario.
The old thingamabobber.
The old thingamabobber.
The flam shooter, Johnson Rob.
All right. See who won this battle.
Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise.
Oh, Lord, he just dumped it.
You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay. You want to call it a blue
I agree.
Blue
Marissa.
paint test?
Yeah.
Sure.
Okay, let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okay.
So your blue paint test
I call
involved
it
painting the right rear tail light
kindergarten
blue,
hand painting
correct?
test.
Correct.
Positioning the test subject behind the tail light, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
Talking about the one they backed into.
Let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one, okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that
if he was standing on the ground,
that you say shows the Lexus SUV
not the
was
sidewalk.
traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let's just revisit what he said was like,
No.
absolutely not.
Excuse me.
On his arm.
That's what I want to get
All
to.
right, let's hear this again.
So you discussed data that you say shows that shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay.
What? So see, this is exactly why he's trying to get into all these other questions, because if he gets him to say, all right, but what if it was going over 20 miles an hour, would the hand brake? Maybe his answer would be yes. He's acting outraged, like 20 above 20 miles an hour. I would never say such an obscene, ridiculous, absurd, preposterous thing. Is that what he's saying? Because, hey, buddy, that's what the Commonwealth is putting you on to say, because that's their theory of the case. So you're supposed to be supporting that theory of the case. Look at his face. Look at it. Look at it. Oh. Struck her over 20 miles an hour? Come on. Come on. All right, let's go. We are going to jump him.
The answer is no. So did you do a test involving 20 miles per hour?
Look at him.
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mhm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you?
Of course.
Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
Yeah, why not? What would happen to you?
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that test.
Okay. So, sir, what you're trying to tell us all is you was afraid to do the test because that shit wasn't going to work. Hey, Alessi, I couldn't do the test because there's not a chance in hell of that shit working even anywhere near what this guy's injuries are. So I wasn't going to do it and then have you call me out for it. No. I wasn't going to do that. Hells no. All right, let me bloop forward.
Didn't show it. Point is we don't have enough information to be able to conduct that testing.
Then get out of the courtroom. You don't have enough information to testify.
Your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Man, Alessi,
Do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Exactly. Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
Yeah, where is it?
There was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I want to go through the information that you don't have.
Okay, doke.
So you don't have that. You don't have the point of impact. You don't have.
Well, let him
where
say no to each of
road
them.
There was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
You kind of don't have where it landed either.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right. But my question, sir,
It's not supposed to be the focal is what he's saying.
But aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162.
I'm going to go back, but I just have to say, I wish this was going remotely. And I know Bob's been saying it. This is not going to be Trooper Paul, not going to be able to just walk all over him. But I just wish it looked something like what Jackson did with Trooper Paul. But he's, like Bob's been saying, he's a professional witness. He's just not going to let Alessi get the flow, and he's just going to make it, really, really difficult. But I'm sure what Alessi's building up to is, again, because he tried to say, this witness tried to say, well, if John O'Keefe was standing on the curb, that for the taillight to hit him, the tires would have also went up on the curb. No, the tires are, several, I don't know, inches, feet. He's got the scan. You can definitely hit somebody with the bumper of a car and the tires are not hitting the curb. So he doesn't even know where John's standing. All right, let's go.
To do.
Let's go to
I rewound it, so.
On direct examination, you testified that after the 1162-2 trigger event, Miss Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Wool gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Just you stay.
Well, I want
just
Mr.
wait.
Wool to go through it to check.
You just wait there, buddy.
Let me ask it this way, see if we can get to it quicker.
You're-
Do
you're
you
with-
remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay. She's like, I don't mind because this is really not
That's
effective.
36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolf, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolf, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. To the farther to the right.
Oh, what? What?
I'm not the only one that has problems.
Jeez, just shut up, buddy. Just
Okay.
sit there.
You
Sir,
still
do
don't
you
have it.
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. Yeah, a
Is
little
that
more.
53 number down there? That column?
Right.
So if
can
you
we
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's see where the one next to it says minus 53.
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157.
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right. And what is the 87 feet traveled? Is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So
What?
you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
Just
please-
hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to.
7 feet off.
How many
Earth.
feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well,
All we
that's
care
what I want to
about-
get to because I want to have this point.
How many feet at that one time?
How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense.
Yes, it does.
Because when it went forward, then it went in reverse.
Right. So all we want to know is how many total feet in reverse? 87. It Sounds like he's saying 87.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So
87 feet.
Total.
You've testified that the
Changing
1162 trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
What he said, babe, was he went
Could you
34
zoom
forward
in?
and
There
then
you go. No, go back to the left.
back to the starting point and another.
So that
degree.
T in the third column for data ID represents the trigger. If you scroll over a little bit to the right where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is
Right,
this
5
10 second window.
Right.
And so
5 after.
we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet
Only
and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
Yeah, I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
okay,
but I'm an engineer. Okay. So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet. And is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1 represents drive?
Correct.
A 2 represents reverse,
Correct.
or a 2 can represent slowing down. Is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down.
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolf. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Alessi, so is this 30 or 31?
It's I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you.
Good job, Judge.
You see all the numbers in blue font on that slide, sir?
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says shift position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct? As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Woke, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
Exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
That was me.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
in reverse.
Okay. Got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
I mean, it doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Jesus
if I may try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this.
Who keeps doing that? It's making the screen too small. Is that Allie or Mandy? Leave it be, please. I like it over here. I don't know who keeps moving us to the right or to the left. Is that Allie or is that Mandy? Show yourselves. Babe, do we have any blooping? It's not me. It's not me. I moved it back. Somebody asked if we could make the screen bigger, and I'm like, we had fixed it, and then somebody moved us back over there, which makes it smaller. I don't know.
All right. I was talking to your dad. Hold on. I don't know why it keeps
leave it.
moving it
Just
up.
leave it. That's good. Right there.
I didn't do anything yet.
Well, somebody moved it over to the left, and it makes it more narrow. I don't know why.
All right. That's as big as it gets, no matter.
Yeah, no, when like somebody moves this over here, it makes it smaller. See? So just leave it over here.
It got smaller again.
No, it didn't.
All right. Put it back.
Look, boop, boop. Small, huge.
Here, put us over there and I'm going to fix it. Stay right there a second.
Huge. Why do you care if we're on the left or the right?
Mandy says, so people watching on their televisions can see.
No, we are not cutting off any of the screen when we're over here.
Oh, yeah. I don't know what's going on. I don't know why it's actually is smaller.
Yeah, it's smaller.
Or, no, I'm making it bigger. Now.
Because I can see exactly what you see. You never see Judge Cannoni. Like I see the full screen. I have a full monitor here. We're not cutting off Judge Cannoni. You don't see her. Like they have to pan out for us to see her with their bizarre grins.
All right, let me see if that's the same thing. Yeah, it's exactly the same thing I see on the screen. Like we cut that woman's face. That's where it ends. Hold on. Yep, there we go. Okay. Okay.
Now we're bleeding into the screen.
No, we're not. I that's literally, I'm looking at the screen on the TV. She ends right like at her second eye in her hair. So we're literally like, that's what's showing on Boston 10.
Okay.
I promise.
I'm about to hire Welcher, see if he can figure it out.
See that zooming in on her, you can only see half her face on their screen too.
Okay. I trust you, babe.
Mm-hmm. I'm looking at like just her nose. Oh, let me bloop though past this shit.
Well, it could have been you or Allie.
Doing what?
I don't know. Like whoever was
Dr. Welcher,
is that Elizabeth?
Am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
This again? He started this
No,
over?
it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
That looks good, babe.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12.
Hey, did your guys' screen just get brighter on your end? No one noticed? I brightened my screen, and I was wondering if, since I was sharing my screen, if it got brighter for you guys, but maybe not. Okay.
Yeah, I'm not grumpy. I'm a little frustrated with the cross. I'm not gonna lie. No, I'm a tad bit frustrated.
No, they're gonna have to call Trooper Paul.
They have to call Pooper Troll. I mean, they're gonna have to. Like he just can't. Like he just can't crack this guy.
No. All right, let's go.
12 and 1 a.m. Do you
back one more minute.
want to talk about the inside of the house, but just that we're at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir?
Grumpy at Allie,
approximately.
I believe I do.
And what is that number?
Grumpy at you now.
Do you want them people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh.
So Mr. Alessi, just move to the last question.
Right, sure. So,
last question.
Sir, did you
that what he
assume
said?
that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview?
At 12:32. Let's say that. At 12:32.
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding. In terms of on the street, is
On
your
the
question.
street,
Yes.
And do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Did you have any understanding as to whether there was a Jeep vehicle on the road
on the street
at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So we're going to let that answer stand, what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162.2, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with the vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What if it didn't?
What information do you have?
Just ask him. Let's
with
but let's
regard
assume
to
just for my.
How many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
Instead of forcing him to accept that it's there because everybody knows that it's there, he should just be asking him, you know what, for the purposes of this hypothetical, let's assume if there was a car parked there, it would have to have made contact, right? Let him keep thinking there was no car there so that he's more inclined to be like, well, yeah, if there was actually a car there, you know what I mean?
Yeah, I know.
All right, let's.
I don't understand why Karen's fucking statements have any impact on what a biomechanical / biomedical engineer is figuring out in terms of the physics and the kinetics.
So that's why I'm saying,
do with it. Like all that does is lock in his confirmation bias. He's working his way backwards from an answer that he's supposed to get in order to make it fit. And he's taking into consideration things that have zero impact on the physics and the kinetics of what happened. Is he not going to get into the fucking taillight?
I don't know if he's saying the last question.
The taillight and how it exploded. My head's going to explode right here. So everybody brace yourselves.
It could be the last question on this topic or before they break for the day because he's about to move to a new topic. I can't imagine that he's done. If he's done, they've scored 0 points.
All right, babe.
I don't know.
You're making me feel a little better, hopefully. I hope you're right.
But I still wish don't let him realize the car was there. Let him keep assuming it wasn't there. And then say all right, but if there was a car there, they would have hit.
Statements of a number of witnesses. I don't know if I'm allowed to say the names.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front of 34 Fairview.
And let's assume it's at the
Is
edge
there
of the driveway.
A likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather, I don't think necessarily plays into whether there would be a collision or not.
But the distance
But we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
Okay. Yeah,
57. If something is within that window, then it would hit it.
All right, good.
Go.
So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side. I'm simply showing how far it moved forward.
Am I fucking confused? Can everyone in the chat tell me, is there any debate, dispute, disagreement that Higgins' car was still there when Karen left? Right? Babe?
You
Chat?
see us, the chat. Yeah, no, they're wait. When you're talking about when Nagel was still parked there?
Nope, when Karen left.
Or when Ricky?
When Karen left.
That there was still what parked there?
That Higgins was still in the house.
Yeah.
There's no debate over that.
Right. I mean, like we haven't even heard about the Jeep at all.
Right, but I'm just saying that he, for his scenario, he just said it. Well, yeah, if there's something parked 53 feet behind her, and clearly, and again, that's from where she started because she goes up 34.
With a plow blade on front. So
right, she comes up 34.
6 more feet.
She comes up 34. She goes back 34, and then another 56. So if there's anything behind her in 56 feet, there's a collision. If not, she's on the fucking grass. Those are the two options. So look at his face. Look at it. Wow. We're blooping forward though, so we'll see it again. Oh, got even a better one. Here we go.
That's his
Showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Right. So
check
87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather
have nothing to do with where you start.
Finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you
Yeah, he doesn't
described,
need the conditions. It's true.
it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting? You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable.
But you gotta
I would need
do it
more
with
information
where
to be
you
able to
think John
determine
O'Keefe was
whether
struck.
it's reasonable or not.
Where his
It's
shoe was
certainly
found.
possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
Oh, wow.
It's a possibility that
Absolutely.
this Lexus could have
Not
been
a
shot
great
off
answer
into
for
space.
this guy.
Highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality.
Yeah, let's
So
do that.
in terms of the
Let's get back
Lexus
to reality.
itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the
Why
lawn.
the hell
You
do you
can't
want to
rule
put
that
this
out,
vehicle on
can
the
you,
lawn?
I
sir?
cannot. No, it could have.
Okay. Now let's go to
I thought he
The
was
next
trying to
topic.
say it didn't because there were no tire marks on the lawn.
How would they know? The snow.
If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167.
You can tell the car goes on the lawn.
Yeah, you can. That's true.
But I thought they were trying to say there's no evidence of that. He didn't.
Now, as
hit
I
the Jeep.
understand your testimony, Dr. Welcher, you believe that it's
wants
possible
to know.
that the Lexus taillight could have caused these wounds
Oh,
to
finally.
Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know, I'd characterize it that way. What happens is, there's 6,000 pound vehicles coming and he's standing on a, icy, snowy roadway area. It's going to contact him and move his whole body and induce rotation.
Up, pirouette.
Right. So it's going to contact him.
Did it.
And under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
No, because your slides
Sir,
are up.
I'd like to answer your question with a slide that I have
You look
that
at this
addresses
slide.
this exact
Look at
point.
what he tells you to
I'd
look
like
at.
to stay with this slide, Dr.
Right.
Welcher,
Put your
and
shit
see if you
down.
can answer my
Fuck
question
your
off of this slide. So I'll repeat it.
Sure.
Do you agree
Sorry.
that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but
I don't
the
know how
upper
to
ones,
operate a pointer.
I know it's not your fault, but
on the
sometimes it
image,
doesn't.
the upper left. I mean, technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking
biceps goes all the way to the elbow, so do the triceps.
Right. So I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree
Mm-hmm.
that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are
just shut up.
Trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're
Stop
angled
getting all
down
nervous
slightly, but
already.
more or less horizontal.
Shut up.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body,
When did
it's
it
going to
break?
make a horizontal
Fuckface.
laceration because the 6,000 pound vehicle is going to push me out of the way. A
And when did
horizontal
it break?
laceration because the 6,000 pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm.
Flat
This
surfaces.
is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the car, it's pushing and pushing across like this. And with your arm
How's it
bent
going
like
down
this,
there?
it's going to cause laceration as it pushes my arm
I thought it was
away.
pushing
It
up
pushes
there.
like that.
Okay, I
And
got
it's, my slide shows this quite clearly.
So you disagree.
Oh,
You
God.
do not agree that the injuries to Mr. O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more.
Oh, God.
You're going to have,
Oh,
again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And
flat surface.
therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory, right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay.
As long as you don't leave my slideshow, it all makes sense. But once you venture off of there, I don't know.
Isn't it the case with your theory that the tail light would have to break?
Here we go.
And after the break, the arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car.
But it's
for some
stopped
time.
moving.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact. But the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next
Run
question
over.
is simply,
Run a fuck
how
over.
long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks, to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right.
Exactly.
You don't have enough information to make that determination, do you, sir?
Correct.
And
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
Well, it sounds like you're
So
saying
now
it
when
did.
you apply the
The
law
scratching and the breaking.
to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. Because you
No.
didn't do that in your report.
Nope.
True.
Always applied the laws of physics. The
No.
paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that match. So that was an engineering experiment to correlate height, position of the taillights relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law.
Oh.
There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Oh,
Sir, I have your entire
because it has
report
kind
in
of.
my hand,
I'm
right
with
here.
Andrea S.
Where
God.
in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me
I
to where?
applied it, though. I didn't write it. I
would write a
applied it.
report that said, these are the laws of physics. I would say, these are the numbers. But for example, the timing in GPS, how a clock times, the concept of a second. What does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A, 2A Roman numeral 1, 2A Roman numeral 2.
Slow down.
2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3.
Has anyone?
You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570.
That's
Can you read the next sentence?
I'm sorry. Is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report.
Doesn't mention shit.
Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis.
Okay.
But
so
in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
Jesus.
So now let's
fuck, guy.
Go to the.
All right, before they move on, I think SR has a point here. I don't think anyone's testified this trial to Higgins' Jeep being out front. I think we're going to need Higgins. Because I don't remember whether.
How's Higgins going to help?
Well, he's going to say he's the one that says he parked his car right there with the back tires against the edge of the driveway and the rest coming towards the mailbox.
Wait, you've moved back to the going in reverse and.
Well, it was just because SR had this super sticker and it was a good point. I don't know that I don't remember Jen McCabe. Maybe she did, but I don't remember her testifying about Higgins' car being there. It's an important fact at this point. He's just said if that car was parked there, it would have been in a collision. So All right, let's see where he's going next. How does lights get into the yard? Yes, we still don't know. We still don't know. With the laws of physics, right, Mickey?
Horizontal movement we were talking about with regard to the car. And you can agree or disagree.
I think I'm back, guys. Sorry, that's good points. All
I'm sorry, we'll take that down.
from earlier.
Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So,
You're not.
Like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay. Are there only two variables you need to answer the question?
But this is a good start.
All right. So let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations. But again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations.
Generally.
Okay. Yes. Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want, we bring up a slide? Will that help you?
I'd love to bring up a slide.
We're going to be running the thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it, but I think we've got a slide for you.
Happy birthday, Elizabeth.
Happy birthday.
111 is on the screen, sir.
Do we have ads? Somebody said there was ads.
Say what?
Unless they're watching that one time I had an ad.
Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
There's no ads, Milo said.
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car is moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If you could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint
Tony
featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All right. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
What? We're getting an ad.
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
That's not what I think, sir.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
I am not going to be asking any questions that involve the taillight in any fashion. So what I'd like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight on the Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method
You started with what didn't happen.
earlier has
I think I was muted that whole time. I said
identified
hi to
various
Iris.
hypotheses? Go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked
about
at how
not the
the
Lexus?
rear system worked to see if it would
Hypothesis
autonomously brake.
that he
I
didn't get
confirmed
hit
it
by
did
a car.
not. So I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
What
understand
about
you say you did a bunch of tests on the vehicle. My question
other
is,
hypotheses?
did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do
God.
One static and two dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
I just hate him. I hate him. I hate him.
It's in the file. I gave it to you. Some of the slides are some of it.
Oh, I got it's in my
All right,
slides.
so Mr. Alessi, I think if we're going to,
Call it a day.
I'm going to move on, Your Honor.
No.
So-
okay,
Call it a day.
Mr. Alessi, hold on, we're going to do that voir dire.
Yeah.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could,
Okay.
please.
I wasn't finished my
Go ahead, finish your answer. I'm
So
sorry.
slides 109, 110, 111, actually
what a
through,
fucking punch him.
I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another
Yeah,
time.
we're going to come back to your
Dr.
stupid
Welcher.
hypothesis.
So
The
what I
same
want
thing.
to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this would be my last question, did
The
you
answer is no.
engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
predicament.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do.
We're ahead of time.
Investigation.
Jurors, don't worry. Don't worry.
Your voir dire.
If I have a moment, Your Honor, to switch.
Your Honor,
Yes.
can I have a look at my slides?
This guy in his fucking
Yeah,
slot.
can you do that while you're sitting here answering questions? Yes.
Can I what my slides? Can you shove them up your
Look
ass?
at these slides.
'Cause
I
there's
need
such
my
a-
slides.
Without them, I don't know what to say or do.
Your Honor, I need my slides. Your Honor, what about my slides? Can I put my slides up? I need my computer in front of me.
I
Your
think
Honor.
the voir dire is going to be about the times, the key cycles and the times.
Oh God, he didn't ask the question how the taillight exploded. Like he asked about broken bones in the hand, but he didn't ask what amount of pressure. I wanted him to say, well, he had to be going 8 miles an hour. Okay, well, where's your fucking homework on that? Where's your physics on that? Is that in your report? I mean, like this whole simultaneous, there's so much fertile ground in that area of the cross with respect to this whole concept of somehow like it's like we're in the Matrix.
How the pieces
It's like
got in
the
the yard.
taillight explodes and then stops in space, and then John's arm drags across the Matrix frozen taillight.
Pieces.
And then once the scratches are done, it flies off into the air. I mean, like that's what he's saying happened. Like what like John would have been under his theory. John's moving immediately. Right. I mean,
Or he's run the fuck down.
He's run the fuck down.
Wait, did I pause it? What's happening here? I did. Why did I do that? Sorry, guys.
I'm going to start with Your Honor with regard to the true fall.
Okay. And we're on a very limited schedule here. Okay.
Oh, just, you know what?
Your Honor.
Judge Canoni.
Mr. Wilk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36.
I put it at 125. If you don't like it, tell me.
You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to
don't
go through
recall
this quickly. Mike, that image is a drone image on the left, correct?
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report?
He needs to get a transcript of this so we can do it this way tomorrow. He needs a transcript from the first voir dire.
Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint. Yes, it's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With Your Honor, why did we?
He didn't start there, but 300K.
I have limited. Go ahead.
So that particular diagram I did not use. If you notice, the diagram I use has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report.
Thanks, Andrea and Iris.
We have the hard copy.
Babe, welcome, Iris. I
Turn the lights on.
thought I told you that when I wasn't muted, but I was.
Welcome, Iris. Aw, family hug. She a new member?
No, she came over from Auntie Deb.
Love it.
Deb said she should come. You know, I can't find the thing anymore, but and then Andrea followed up.
I'm going to yes, Mr. Brennan. This is. May I put you in? Should be Dr. Welcher. You see this first page? You recognize this as the cover page for the Trooper Paul report that I was referring to. You want to look at the report? So I'm not so sure there is a signature on the report.
Can't the judge just tell him it's Trooper Paul's report?
Right here. Yes, Trooper Paul, page 16.
I have that. Yes. Okay. Now, what I want to do is to go to diagram 1. And if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass top, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different. None of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Okay. Thank you. Probably the same one. You took
Do you
off
know
the
of
measurement.
any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay. Did Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
He's on his computer, Judge. Did you okay that again? I guess they don't care for voir dire.
Sir, let me know you've had a fair opportunity to answer that question.
I think she okay. Remember, he was talking about his slides.
Yeah.
Slides.
I'm going to see Lila
Yes,
after
it came
this.
in a file called cars.
I don't know how to get in there. We have an away game.
ERP.jopal.
Okay.
I'll meet
So
you
it
there
came,
later.
and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can
Cars
you repeat again
file.
what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name
Yes.
is cars-trp.jopal.
Okay. And did you get the drone image from that file folder?
I did.
Okay. Thank you.
God,
You're welcome.
Now
damn
let's
it.
go on
Fuck's
to
sake.
the May 26, 2025
Somebody strangle that
PowerPoint
man.
you created. And I'd like to go to slides 25, 26, and 27.
Ugh.
Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to,
What the hell is it?
where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on?
Just,
What slide is that?
oh,
25, I
Right,
believe.
okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is,
he relied
May I
on
approach, Your
Trooper
Honor?
Paul's
Yes.
shit.
thank you.
So that's what this is all about. You're getting in what Trooper
Let me ask
Paul
you this
said
right
he
now. Keep
did.
going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
That's
Think
perfect.
so?
This is
Can you
Remember
pull
the-
up?
the
Can you pull up
name
the
of it?
key
I
cycle
don't.
grid?
With the hard
this
copy.
is voir dire though.
I know, but
So
I think this
if I
is
could,
prove that
approach,
he.
So you see what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
Is this the same report? Dated 1/29/2022?
I believe so, sir. Let me just-
Hey, 1,000
This
likes.
is- you can just compare this
Sweet.
to the one I have in my hand.
Thank you, guys.
Woohoo!
For any
You guys are
application
good
that you can,
today.
right?
Woohoo!
Yeah, mine's from.
All right, I'm gonna rewind.
Identification that gives you.
I was
You can just compare this to the one I
going
have
in
in my hand.
time.
Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's from.
So here's what I think is happening. I think that he's trying to establish, the defense is trying to establish that this expert relied and had in his available material Trooper Paul's reports, Trooper Paul's key cycles, or whatever he wants to call them. Trooper Paul wanted to call them key cycle, ignition cycle, whatever, so that he can get all that shit in and the stuff about the time. But let's see.
Okay,
So that's 2 papers.
okay. So we have that report,
Mhm.
and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty.
Mm.
Now let's
That's
go
right.
to.
And I didn't use it. I didn't use it.
You're continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 10 past 4.
Okay, Your Honor.
10 past. It's already 15 past.
It's true.
Oh, we're ahead of time?
Wait, are you? Wait, ahead of time we've gone into the future?
You see these photos?
Behind
Sorry,
We're behind
You see the
time.
photos that are up on that?
I do.
Okay.
10 minutes.
Do you, in terms of those photos, do you recognize any aspect of those photos?
Oh, perfect. This is what I
Yes.
wanted to
What do
know.
you recognize in terms of the person in it?
Oh. You want me to limit it to just these 3 photos?
Just what you know.
Any photo that would be this photo or any photo similar to it. But let's start with just these 3.
Cooper Trawl's hands.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
12, 6,
I have
6,
photos
5.
of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
Sorry?
Inside the vehicle doing what's depicted here.
That's key cycle
Someone's inside
1164,
the vehicle
buddy.
taking the photograph.
What's your best conclusion as to
1164.
who that is?
All your
Paul.
Thank
shit's
you.
wrong.
Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just,
All their shit is wrong. That just confirms that picture, he thought it was taken as soon as it got into their possession or whatever. That's Trooper Paul's testing. Tracy sent us over the exhibit from last year, and as we've all been saying, Trooper Paul's testing was 1164, not 1167. So all their shit is fucked.
So Stephanie had asked, what's the purpose of a voir dire? It depends. Typically, if you're trying to voir dire a witness, the judge will want to hear outside the presence of a jury.
Whether you can lay like, sorry, babe, whether you can lay like a certain foundation to ask certain questions. And I think that's what's going on here. It can be like numerous reasons, but mostly it's, are you going to be able to ask these questions in the jury? Well, it depends what he says to these other questions. So I'll let you ask these other questions and your questions outside of the jury. If it meets a certain, whatever they're looking for that specific issue, then they'll say, okay.
In this particular circumstance, so like this arose from when he was trying to bring up the key cycles and the trip thing, and Hank kept objecting, and then they went to the sidebar, and then he pivoted completely off the key cycles. Obviously, what happened in that discussion is the judge says, well, I need to know that this guy actually used Trooper Paul's report and has his own knowledge basis based on what he learned from that report in order to allow you to get into because that's what Allie was saying. Like that, it was probably facts not in evidence. And if this guy, he was being very slippery about whether he had used any of Trooper Paul's information, any of his shit from his report. So she made.
We think that's what this is all going.
I would almost guarantee it.
Right. All right. Let's go to the next topic, I guess.
just need to reload, if you will, with regard to that topic. If you could, if Your Honor, you can go to slide, and I think I can do this fairly quickly.
Okay.
If you
Aaron's
can
on
go,
it.
Mr.
Aaron's
Woke,
on
to
it.
slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132.
So we think
I
it's
don't believe that's the right one. It's the
One before that.
Yep.
get
I think
Trooper
you're-
Paul's
yeah, okay.
cycles in with
So
this.
this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct? Is that where you got that from?
It's from the report. Take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Yep, I got it. Yep, thank you. If you can go to the very top line, it says autopsy report performed by Irene Scordi Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
It's because Brennan's
You
trying
are
to deny
all
that
set,
shit.
Doctor?
Brennan's like, he didn't use any part of the ME's report in his shit. He didn't use any part of Trooper Paul's report in his report. Oh, no. I'm going to gaslight everybody.
Thank you, Ron.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep it under 2 minutes?
Oh, I thought she said she's done. She's done.
Stacy, that's what they're trying to figure out. If they can't get this,
Dr. Welcher, you were shown a photograph.
Sorry, go ahead, babe.
I was just saying that if they don't get this in, if she doesn't allow this line of questioning tomorrow
With this witness, right?
with this guy, then they might have to call Trooper Paul to get it in the key cycle shit.
But the point of this is not whether they are allowed to bring Trooper Paul or not. It's whether they're allowed to ask this witness the questions like Bob's been
About the key
talking.
cycles, right? And this guy's like playing stupid, like he doesn't know anything about it, and he doesn't know anything about Trooper Paul's key cycle shit.
Right, and
But
the
they
ME
have
stuff.
to get it in. They have
And
to
the
get
ME stuff.
it in,
All right.
especially if it's incorrect.
Yeah, it's definitely incorrect.
Of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No.
Of course not, Brennan.
Like that's opinion for that.
Did you ever have a conversation with Dr. Scotabello about her expertise limitations?
No, I would
What?
want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
I don't. He's making a stupid point.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just gonna
I have
decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scordi Bello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here
Are you just
for the
pick and
autopsy
choose?
report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall the slide that you had has the final diagnoses of Dr. Scorti-Bello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death.
He doesn't
There's
give
that
a fuck.
horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered that.
Correct.
Thank you. No questions, Your Honor. I appreciate that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Alessi, how much longer are you going to be tomorrow?
Days.
Yes.
Depends. Will this fuckface answer a question directly?
Right.
Ask this guy.
I'm about halfway through, Your Honor.
Halfway through.
Yep.
I think it will take up, look for it tomorrow. If we can get some things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Might not finish.
Better skip that morning break there, Judge.
So it may be that we have a 20-minute break tomorrow and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day.
Too late.
So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case.
Right.
And we've got to be able to proceed through with the question. He covered a lot
And-
on his direct and he properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
I'll give you my answer if that's the point.
Okay. All right. Thank you.
Wow.
Wow. All right. So that was a frustrating day for me. God,
That was like,
it was like, but somebody made a really astute, I think it was Larisha. She's like we do look at it through the eyes of a lawyer. It's like for us, everything's about winning a point. You know what I mean? And sometimes I tend to forget because Steve Pachenko, my buddy from the amazing podcast, Trace Evidence, he was saying, I want to read he's like, he said, all of this testimony has me as a layperson completely lost. All that I am getting is that this witness seems quite hostile. And I'm like, yeah, it's a frustrating cross. And I'm like, this dude ain't Trooper Paul. He's probably testified 1,000 times in civil trials. Yeah, but and then Steve said, yeah, but that's the thing. If I'm on the jury, all I'd get about this guy is that he really doesn't want to give accurate information. He just wants to give information to hurt the defense. That's how it feels to me. And I'm like, good, you are the jury. So, you know, I think that I have to try to remember that because I get frustrated, you know, when I'm watching it. And, you know, from our perspective, you know, there's things that you can, you know, tighten up in terms of like armchair quarterbacking from lawyer to lawyer. And you guys know how much I love Bob. And like, I'm glad that he's got a night to tighten shit up. And because I mean, there's still some big points that have to be made. Like I hope he's not moving away from the exploding taillight. Like he's got to dig into that. He just has to. He has to make it sound just as implausible as it is. You know what I mean? It's like that. It's something that he's got to do. All right. So I've got the wheel all set up. Additionally, there were 4 people that had donated that I didn't get on the wheel on the 21st. And that was John Miller, the great John Miller, Zila, and Susan C, as in addition to Chrissy C.
I added an asterisk to the banner.
All right, so I think I got everybody on for Wheel Wednesday.
Andrea says, Bev, you are the closest. We know he is even on your last nerve.
If you've never done the wheel or seen the wheel, so once we spin, and if you're the winner, you go to our bonfire store, which we'll post here in the chat so that y'all can see it. And then from that point forward, you're going to pick a t-shirt.
Or you just work on the wheel. I'll tell them. You pick a t-shirt and then you'll email us.
I'm trying to pull up the bonfire.
All right, go ahead. Then you'll email us and we'll give you the email. Tell us what shirt and size and address. And we'll send it to you.
In color.
Color.
Yep. All that stuff. All right. Okay. Let me pull this up real quick. So
Mickey says, amazing how he answers questions so quickly and directly. Yeah. He's quite skilled like that.
All right. So here's the store. You just go in here. We got tanks. We got tees. You're limited to tanks or tees. The hoodies, they're not up for grabs.
Not on the wheel.
They're not on the wheel. Got many different styles.
We did have somebody choose to upgrade. So
we did. So you go through. Megan wants a Team Alley for. My personal favorite's the simple Just Facts. I like that one. So, but you guys, it's your choice. All right. So that's how that rolls. And then let's go here to the wheel. All right. I got everybody on there. It was 50. Like,
do we have music we can use for it or no?
I mean, I don't know.
I'm not getting it. I'll just wait for applause at the end. Go ahead.
Yeah.
Oh, we could use Larry David. That's kind of.
All right, ready? You guys ready?
Yeah.
This is exciting. I always love this. Okay, there it goes. There it goes. Round and round. Where it stops, nobody knows. Oh, Meg.
Hey. Brought to you by Rinse and Rise and Heinz.
I love it. All right. Okay, Meg. Use the email. Get me the intel, and I'll order it up. Takes a few weeks from Bonfire, but because they custom make it and then they'll send it. It'll come directly from them. So, did you thank everybody, babe?
I mean, I think almost everyone. I hope I didn't skip any. Somebody yelled at me once because I missed them, but Mickey says in the morning he needs an instruction on answering yes or no to these questions asked. This is dragging because of his response to defense. He answers Brennan directly and quickly.
Yeah.
Sure does.
I mean, that's a technique. But a lot of that is on Bob. I mean, you have to control across. That's the whole point. And I mean, he can.
But when you get an expert witness,
right,
a professional witness, they make it impossible. It gets like
but
that with
Bob has asked a lot of like open-ended questions that just allow this guy to like puke a bunch of shit out. So
even when he doesn't, though, the guy is just like, well, I need more.
Yeah,
well, maybe,
you know
maybe
what that
not.
guy is. It's the perfect word for. He's a blowhard. He's just one of those guys that loves to hear himself talk. Smartest guy in the room. He's never wrong about anything. He's a fucking blowhard. So,
all right, it's time for me to go visit my granddaughter.
Hey, love it. New sub from Nola. You just missed the
New
week.
Orleans.
Very swampy. We love Nola.
New Orleans.
It's our favorite city in the U.S.
That was the most frustrating day so far. Love y'all.
It was a frustrating day. So, all right, but there's always tomorrow. So, like they said, half day, we're back to our normal time. Remember, mark your calendars. Bettero's joining us tomorrow night at 6:30 Central.
Meg P wants to donate to someone in chat. If you want to, you're more than welcome to.
Yeah, there's a ton that are dying to get shirts. Maybe go through, Meg, and see like there's definitely some folks that have really been trying to get them a t-shirt. So, but again, 6:30 Central, 7:30 Eastern.
And that's very
tonight,
sweet of you.
Thank you, Happy Annie. We love you guys so much. And we look forward to tomorrow, another day. And
All right, well,
if they finish, I think the Commonwealth's done. If they finish, if Bob's able to finish, and then Hank handles the redirect, and if there's a recross before 1:30, then I think the Commonwealth rests, and then we start the case chief on Friday for the defense. So, all right, you guys are amazing. We love you so
Meg,
much.
we'll circle back if you decide to do that tomorrow.
Mods, thank you so much. I almost forgot again. We love you guys so much. Thank you, Mandy. Thank you, Tracy, for everything that you do. Elizabeth, happy
birthday.
1,000 times over. Go celebrate you tonight. And anybody else out there that has a birthday, we love you. Happy birthday. Because without you all, I'm just an old man.
Talking a lot of shit.